The time is 9 a.m. and I'm calling this Citrus County Code Compliance hearing for October 2025 to order. At these hearings, we follow an agenda, I think a copy of which has been posted publicly. The first item on the agenda is the call to order. The second item is the pledge to the flag. So as you are able, can you please stand and join me for it? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
All right, the next item on the agenda is approving the minutes from Wednesday, September 17th, 2025. Does anyone have any proposed changes, modifications, or otherwise? I have one. The date at the top should say September 17th, 2025 instead of August 20th, 2025. But that is the only change that I see, so I will approve the minutes with that modification. Staff update?
We do have staff update, case number 2025-1352, Elizabeth Schmieder. She had called and stated she cannot be here due to some medical issues. We ask that we can continue that case.
Okay, does the county have any, I presume that the county does not have any pressing health, safety, sanitary concerns at this time?
No, not at this time.
I saw that look. What kind of case is this?
This is a pool violation, but an inspection was conducted yesterday and the pool is secured and covered. We just need the specifications of that cover to provide to our experts to see if we can abate it at that time.
Okay, the hearing is continued on case number 25-1352. All right, does that conclude the staff update? Okay, so ladies and gentlemen, good morning. My name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over this hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I would appreciate it if you'd pay attention, even if you have heard this spiel before. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call the case and I will allow the county to present its case. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case or defense regarding the violation. That will be your opportunity to present evidence and make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case before me. I will ask whether or not you are contesting the violation. If you do not contest the violation, I'll assume that there's a factual basis for the violation and proceed to ask you how much time you need to fix it. This will help save time for yourself and others. You are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of the parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that I give you a time to comply before any fine begins. That means that you have to fix the violation by the date that I give, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county also has the right to foreclose on that lien or seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about that or their rights generally to seek legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate this into all of my orders as standard provisions. If you bring your property back into compliance with the code in the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs as well as the cost of the lien that's imposed. Although it has only happened a few times, I may continue your case if I find a need for further evidence or argument. There are 2 cases like that today. And you do, of course, have the right to appeal any order I make today as provided by law. Thank you.
First,
and just so we're on the same page, it's my hope that we can take the no contests first.
Yes, sir.
Okay.
We ready?
Yep. Oh, I see what you're saying. Okay. I'll let you.
The 3 no contests I have are because of the issue created. That officer can't be here to talk to any of her people, so we may have more no contests after that case once that officer can come back into the room.
Okay.
They're not here. He's
Well,
that end of it.
No, well, actually, let's bring that case up then. Let's talk about it.
Okay. First case on the day's agenda, Michael R. Novich, case number 2025-1388, Code Officer J.C. Charlton, page 24 of your agenda.
that one.
You'll be here, yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Please state your name.
Michaela Riley.
Okay. First of all, well, actually, Ms. Riley, in what capacity are you here today?
I'm Mike's partner.
Okay.
And we thought he couldn't be here today, but
That's what I was afraid of. So, Mr. Charlton, do you want to first announce have you put your name on the record?
Code Compliance Division Director, J.C. Charlton.
Is that microphone working? I don't see.
I'll turn
Okay,
it
there we
on.
go.
That was me.
All right, so first of all, what I'm going to say is we're here on a case that I continued from last week because I wanted more time. I wanted to look at the exhibits. I had initially found that there was one component to the violation, which was I guess Mr. Novich called it the bamboo in the front.
Mm-hmm.
And do you reside at that house, Ms. Riley?
Yep.
Okay, all right. And the reason by the way, it's not like a criminal case or something where if he doesn't appear, there's a warrant issued or
Yeah.
anything like that. You had indicated that the reason why Mr. Novich isn't here is because you all were under the impression that he's not allowed to be here, correct?
yeah.
Why do you believe that?
Julie Wilkinson has an injunction against him, and I guess she's not here today, so we thought he couldn't be here.
Did anyone reach out to, talk to y'all about if she was going to be here, if she wasn't going to be here, or anything
No.
like that?
Mm-mm.
Ms. Harrison, why is that?
It's his court proceeding. There was no question as to whether or not
I got a call, so why wasn't there a discussion? I mean, this is a proceeding against Mr. Novich. He has a due process right to be here. There's an injunction now placed against him by someone who works for the county. I was called and informed about the situation by my attorney. And so I'm wondering why the county wouldn't think it needs to coordinate this with Mr. Novich.
honestly, we've never had an issue with Mr. Novich not appearing. It never
Yeah.
crossed anybody in the county's mind that he wouldn't appear.
Okay.
So the county fully intended him to be here, so the county made appropriate arrangements. So
If
he,
no one had talked to him about it, though, why wouldn't he expect Ms. Wilkinson to be here and then for him to run the risk of violating a court order?
Your Honor, I can just tell you that honestly, nobody in the county, it never crossed anybody's mind that he would not be here today.
That's not my question. My question is, assuming that everyone is aware of the order that comes from the judge, it's a serious order, right? I mean, this
Correct.
is something no one wants to violate. And why wouldn't he expect Ms. Wilkinson to be here knowing, and she is here, why wouldn't he expect that?
Your Honor, he never called, and we made appropriate arrangements. Again, nobody ever thought he wouldn't be here. So to ensure his due process rights, that he was here, we made sure she wasn't, and that she was far enough away that he would
But
not
no
be in
one let
violation.
him know that,
Correct,
and he
and-
would have expected her to be here.
I understand what the court's saying, but
Yeah.
it literally never
Well,
crossed anybody's mind.
Let me
So-
just put it on the record. I mean, I think the county has an obligation to, in other words, there's a real risk that it could be used to the county's advantage. Do you understand? Where if the county has, or one of its agents has an injunction against the very person who they have charges against, it can be used to the county's advantage to deprive him of the ability to appear if someone has an injunction against him. I know the county didn't do that, but so don't take this the wrong way, but I want you to understand what my due process concern is here so that it doesn't happen again.
I have no problem with that.
Okay. I'm going to issue a ruling anyways, but I want you to understand that, you know, this, I hope that the parties can get in touch next time to avoid this. So you know, I was aware of this, and I was under the impression that Mr. Novich would have been informed that steps were taken to not have this be an issue. All right, so I found in the prior case that there, first of all, let me ask if there's other members of the public who want to be heard on this case before I issue a ruling. All right, so I already issued the prior component ruling regarding the bamboo. I'm now going to issue the ruling on the second component of the county's case, which had to do with, I think, the backyard, so to speak. I'm going to hold two things on this. One is that I think that the county has failed in its burden to show that the plants in the back are not Florida-friendly landscaping protected under the statute, generally. In other words, there was undisputed testimony from Mr. Novich that these plants are Florida-friendly, and that they meet the requirements of the statute. I do accept the county's point that while the statute encourages wildlife, it does not encourage pests, but there's also no testimony about actually there being a pest problem. That said, I think the county had a good point and a good argument, Ms. Harrison had a good argument, that it says when it's properly maintained. Like there is an obligation in the statute that there be, actually, let's look at the exact wording of the statute because we want to make sure we give the correct guidance. So if we look at Florida Statute 373.185, subsection B, Florida-friendly landscaping means quality landscapes that conserve water, protect the environment, are adaptable to local conditions, and are drought tolerant. The principles of such landscaping, including planting the right plant in the right place, efficient watering, appropriate fertilization, mulching, attraction of wildlife, responsible management of yard pests, recycling yard waste, reduction of stormwater runoff, and waterfront protection. Additional components include practices such as landscape planning and design, soil analysis, et cetera, and proper maintenance. Where I'm going to draw the line here is I think that if the county wants in the future to surmount that defense, it's going to have to explain why the plants, and it doesn't say native. They don't have to be native, and I don't know that Biden's Alba is native, but it has to be Florida friendly. So if they have evidence that it is Florida friendly, there's got to be evidence that it's not. There's got to be an argument under the evidence that it doesn't satisfy this. I do find in looking at the evidence, however, that there is not proper maintenance on the edges. So in other words, I don't have sufficient evidence to find a violation for the actual plants or the fact that they're over 18 inches in the backyard, except to the extent that it interferes with neighbors. So I see on the photos that there are plants that go through the fence. There's growth. That's a violation. It's not a major violation. It's like the bamboo. I think it can be corrected with a little bit of weed whacking, and so I'm not inclined to give it a lot of time just because I think it can be corrected very quickly. Does that make sense, Ms. Riley?
Yeah.
Do you have any questions, Mr. Charlton?
No, sir.
What's the county's recommendation?
Recommendation is a $50 a day fine.
Okay. I'm going to grant 14 days to bring the property into compliance, and there'll be a $50 a day fine if it's not brought into compliance.
Okay.
Okay, thank you.
Thank you. Next case, Andrew Joseph Quintero, case number 2025-1197, Code Officer Robert DeNaro, page 26 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
I actually have it as page 25 for some reason on my agenda, just FYI.
Which case are we talking about?
Quintero.
Okay, Quintero.
Your Honor, I've been notified this is a no contest case, that the parties have agreed to 60 days to cure and $100 a day thereafter if not brought into compliance.
That's 60 days and $100 a day?
Yes, Your Honor.
Okay. Let's swear everyone in.
Yes. Andrew Quintero.
Good morning, Mr. Quintero. Did you hear the terms of the proposed resolution?
Yes.
And does that comport with your understanding of what the agreement is?
Yes.
Okay, let me just take a look at this. It says 26 on my table of contents, but it says 25 in my agenda, so let's just take a look. Well, we'll survive. Mr. DeNaro, can you tell me about what this case is about?
Yes, this is a case in regards to, this case number is in regards to special requirements of all accessory use in violation of Citrus County Code.
Tell me what's happened on the property, like what's the deal?
Basically, it's storage on a vacant, he wound up putting a mobile home on a vacant piece of property.
Okay, and so you just need 60 days to kind of either get that off the property or get a permit?
I've already applied for the permit,
Okay.
so I just need time to finish.
Ms. Coutu, do you have any concerns with 60 days? And
As of yesterday, there weren't any applications, but we can work with the building division to try to make sure that
Okay.
goes through.
I
That
have a
doesn't
site
seem-
plan permit
Yeah,
that I was applied for.
that was for Phil. That's not going
but
to get
that's-
you there, yeah.
It's still,
No, well, okay,
It's
so my
fine, it's
point is,
fine.
here's my question, Ms. Coutu.
Yeah.
I mean, is 60 days setting him up for failure?
I don't think so.
Okay.
I think he can get a mobile home permit or remove it in 60 days.
Okay.
Yes, thank you.
Then I'm inclined to accept the resolution, and I'll find that well, actually, first I'll ask, are there members of the public who want to speak on this case? All right, I'll grant 60 days to abate the violation, find a violation exists. If it's not brought into compliance as ordered, $100 a day after that, okay?
Yep.
Thank you, sir. Good luck.
Next case, Wayne and Elisa Bain, case number 2025-1402, Code Officer Erica Olson. Page 5 of your agenda, expert on the case, Land Development Director Joanna Coutu.
And Your Honor, while the parties are coming up, I've been notified this is a no contest, 6 months to cure and $150 a day thereafter.
Let's swear everyone in.
Yes, ma'am. Wayne Bain.
Good morning, Mr. Maine. Did you hear the terms that were announced by Ms. Harrison?
Yes, sir.
Does that comport with your understanding of the agreement?
Yes, sir.
Okay. Ms. Olson, can you tell me a little bit about the case?
Yes, sir. This is a vacant property. He owns the property next door. On this vacant piece of property, he has put in a, like a parking pad made of concrete or asphalt.
Okay. So what are you going to do in the 6 months to get rid of it?
So I've contacted a surveying company out of Ocala, and honestly, we've been in consultation with an attorney. So we're going to conjoin the lots together. It's a lot of red tape, a lot of paperwork. I hope I could get it done in 6 months, but I think I can.
Okay. Ms. Coutu, any regulatory concerns from your end?
No, I think survey crews are behind, and that's just one delay, but if you're working and still having a delay, just talk to code. I don't see any major
Okay.
problems.
I think that's reasonable. All right. Is there anyone from the public who wants to speak on this case? Okay. I will find that a violation exists, grant 6 months to abate the violation. If it's not brought in compliance as ordered, $150 a day.
Thank you.
Good luck.
Thank you.
Next case, Anton and Paul Anton Paul Sabrina Burdenson, case number 2025-0274, Code Officer Cody McGuire, page 8 of your agenda.
Your Honor, I was not notified this was no contest, so the officer will have to put the terms on the record once he's sworn in.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, sir.
Anton Paul Barrington.
Thank you.
Cody McGuire.
Good morning, sir.
Good morning, sir.
Well, what are the terms?
So this would have been a one-time fine of $2,500.
Understanding that, you know, I have discretion up to 10,000, you guys normally ask for 5,000, et cetera, correct?
Correct.
Okay. Mr. Berenson, is your understanding that that's the agreement?
I did not have any understanding about a fine, and so I'm asking you basically, I'm going to give you the whole picture of what this.
No.
Okay.
So what I'm going to do is ask you I want to make sure I'm on the same page. This right now is for cases that have already settled in terms of an agreement as to the resolution.
I didn't have an
and
agreement.
So this is a case where the county will, I guess, ask for a one-time fine. So if you're not in agreement with that, then we're going to ask y'all to sit down. Thank you.
My apologies. Next case. Becky Odom, case number 2025-1303, Code Officer Alan Jonason, page 24 of your agenda.
And Your Honor, while the parties come up, I was notified of this one, that the parties agreed to no contest, 60 days to cure, and $150 a day thereafter if not brought into compliance.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, ma'am.
Becky Odom.
Thank you.
Alan Jonason, Code Compliance Officer.
Thank you. Good morning, Ms. Odom.
Good morning.
Were the terms that you heard from Ms. Harrison accurate as to the resolution?
I'll be honest, I wasn't even paying attention, but I think it
Okay.
was 60 days and 150 a day
That's
after
what she
that.
said.
Is that what she?
Yeah,
Yep.
okay, all right.
Sorry.
Now, this is what I, based on the alleged violation, call a quote-unquote junk case. Is 60 days enough for you to clean up the property or arrange to have it clean?
I don't just take this with a grain of salt, but it might be too much. Those people just junk that property.
I
It's
see.
vacant, and the homeless people, and I don't even know how they have so much to store. What do you have?
It's the society we live in. You know, people come into stuff.
They're entitled too. They get mad at me when I go over there and they tell me I'm stealing their stuff. He told me to call the police. I said, you call the police. He said, I don't have a phone.
Hey, people have rights.
They have made tremendous progress. I was there
Okay.
yesterday, and they're doing great
Okay, I just
work.
don't want to
think-
set anyone up for failure,
Absolutely.
but is there anyone from the public who wants to be heard on this case? All right, I don't see anyone, so the terms seem reasonable. I'll find a violation exists, grant 60 days to abate the violation. If it's not brought into compliance, is ordered $150 a day.
Yes, sir.
Good luck.
Thank you, ma'am.
Thank you, thank you.
Next case, Albert L. Tidwell and Rebecca Land Trust, case number 2025-1346, Code Officer Erica Olson, page 40 of your agenda.
And just so everyone's aware, the reason why we do these first is because there is a resolution. We can go ahead and get them out of here and get to your hearing faster instead of spending an hour on a hearing before getting to the people who just want to get out of here. Good morning.
Good morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, sir.
My name is Robert Waters.
All right, and so I think we're here on the Albert Tidwell and Robco Land Trust case.
Yes,
And sir, are you an owner of the land trust or a representative?
I'm an owner.
Okay, you're an owner.
And Your Honor, I've been notified no contest with 90 days to cure and $100 a day thereafter if not brought into compliance.
Sir, does that meet with your approval?
I'm sorry, I didn't hear it. I have a hearing issue as well.
Sorry, a no contest plea with 90 days to bring it into compliance and $100 a day thereafter if it's not brought into compliance.
Yes,
Okay. All right, is there anyone for the public who wants to be heard on this case? I don't see anyone. I will find that a factual basis exists then, and there's a violation, I will grant 90 days to abate the violation. If it's not brought into compliance within those 90 days, it'll be a $100 a day fine. Okay?
Yes,
Thank you, sir.
thank you.
Thank you.
Those are all the no contests that I'm aware of.
Okay. Can we call the Golly case?
Yeah, that's what I was
Okay.
gonna call that one next. Next case, Michelle Golly, case number 2025-0940, Code Officer Erica Alston, page 14 of your agenda. Expert on the case, Joanna Katu.
My question is for Ms. Spiros, or anyone who would know. Did we introduce the doctor's? Oh, okay, I got it. Sorry. Yeah. All right. I just want to review this quickly. It's relevant. Okay. So I reviewed applicable case law in regards to this case. I'm going to put two cases on the record. First is Warren v. Del Vista Towers Condominium Association, Inc. at 49 F Sup 3rd, 1082. It's a 2014 case from the Southern District of Florida. In that case, Judge Martinez held that Miami-Dade County's prohibition on pit bulls, zoning prohibition, did not override the Fair Housing Act's requirements. In other words, in allowing people with disabilities to be able to live in their homes. However, despite the zoning ban. However, there's another case which I think is more on point. It's not in Florida, but it's Commission on Human Rights and Opportunities, ex-rel v. Pizzo Ferrato v. The Mansions LLC. It is a 2025 case at 231 Connecticut Appellate 121. And I think this case is a better example of application under the law than the Warren case, because what the court analyzed here is what the FHA, the Fair Housing Act, actually requires, and what it requires is evidence that an animal actually be necessary to afford a person an equal opportunity to use and enjoy a dwelling. I've reviewed the doctor's note. I think that the note is valid for the proposition that an emotional support animal is necessary, but I do not find that it goes toward what the FHA requires in order to override the county's zoning ordinance. I think that if I were to rule in Ms. Golly's favor, even though I frankly want to, it would be an appeal that the county wins, and I just think the state of the law doesn't allow an overriding of the county's zoning. I mean, the reason why is because goats are great. Goats are awesome. And unfortunately, she's going to have to figure something out. So does the county have any comment or feedback on that? No, okay. Is there anyone from the public who wants to be heard on this case? I mean, the other thing is, I think there's a special consideration for the fact that, I think part of the reason why the county has the code that it does is honestly for the safety and welfare of the animals as well as the neighbors, and it's not enough space. So, what's the county's recommendation?
We recommend $150 a day.
Okay. I am going to grant 3 months or 90 days to abate the violation. If it's not brought into compliance within 90 days, $150 a day. Thank you.
Thank you.
Next case is Brent A. Banks, case numbers 2025-1392 and 2025-1393, pages 6 and 7 of your agenda. Code Officer Alan Jonathan.
Good morning.
Good morning.
Actually, this is is there someone there? Oh, okay.
You're presenting them at the same time?
Yes, sir.
Okay,
A junk and a lawn case.
gotcha.
I'm hearing impaired, and I'm sorry, I cannot hear what you're saying.
Would you like a chair or are you okay?
No, I'll be okay with standing up, thank you.
Did I swear you did?
You did.
Do you swear to tell the truth, the whole truth, and nothing but the truth? So
I do.
please state your name, sir. Your name.
Brent Banks.
Thank you.
Thank you, Mr. Banks. Would you mind pulling down your microphone a little bit, just so that it picks you up a little
Can you
better?
hear me better now?
Yeah, that's great.
Okay.
Can you hear me okay?
Yes, I can.
Okay, great. Please proceed.
Yes, sir. Alan Jonathan, Citrus County Code Compliance Officer. Case number 202501392, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. And case number 202501393, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. Address of the property is 1099 East LaSalle Street, Hernando, Florida. Property owner is Banks Brent A. This property is 1.25 acres and is zoned LDRMH and was purchased on 4 June 2019. I have good service via posting the notices of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 14 August 2025. Photos from my compliance inspection on 15 September 2025. And photos from my final inspection conducted on 14 October 2025. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a photo of the notices of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavits.
Okay. Now, sir, what I'd like to ask you to do is take a look at these documents and let me know if you have any objection to them being evidence.
Okay, explain first that my father has the power of attorney over my estate.
Okay.
Okay, and I'd like for him to be able to be with me here to answer his questions or whatever we need to do. This is, I don't detest that there's all these violations.
Okay.
There's probably more violations
Okay.
than he's got written down there.
Right.
But there's nothing that I can do about it. The circumstances are that I'm not allowed to go to the property for any reason.
You're not allowed to what?
I'm not allowed to go to my property for any reason. The criminal judge ordered that my father and I not be allowed to go to the property. There's circumstances. Okay, which is one Miss Billy Jo Powell's, who's been given an injunction against me for 20 years.
Who's been given an injunction?
Her name is Billy Jo Powell's.
Billy Jo Powell's.
The property does belong to me, every blade of grass and every grain of sand. And but the entire time that I've lived in that home for 6 years, until February the 27th, there was never a violation. I had a groomed lawn, my beautiful piece of property. It's now worth only $8,000. A $200,000 piece of property and home is worth $8 grand. She has destroyed my home and she's destroyed my property. That she not tore up the property. Property's in
Mr.
shambles.
Jonathan, would you mind going back to the microphone?
And
I might
it's,
ask you a question or two.
I'd love to be able to go home and fix all of that and make it beautiful again. It was from the most beautiful piece of property on that entire street to absolute worst in the whole plat.
So
it
let
kills
me
me. There's nothing much I can really do.
let me
about
ask
that.
you then. So it's your you're telling me that there is an injunction issued by I presume, a circuit judge here in Citrus
yeah,
County,
Civil court judge.
civil court judge.
I agreed to the injunction. I don't want have nothing to do with
Well-
this person, or no, I want to have.
Well,
any-
an injunction against contact or distance is a little different than not being able to go to a property.
Right, yes,
sometimes.
I understand, but
Actually,
they-
hold on a second, county attorney.
This is the first I've heard of this, so I looked it up as he was discussing it. The injunction does grant her, the petitioner, temporary exclusive use and possession of the dwelling and provides this address.
Okay. Okay, well that, first of all, I didn't doubt you, but the county attorney's confirmed what you said. It presents kind of a thorny issue because regardless of the judge's order, you are the owner and you have been cited as such. You know, we often have cases where owners are landlords and it's not the landlords that trash the place, it's a tenant, and then they still are held responsible for maintaining it. Let me ask Ms. Harrison this. I mean, and I don't know who makes the decisions for the county on a case like this, but does the existence of this order alter how the county wants to proceed with the case or who it wants to hold responsible? What does it want me to do?
Technically, by law, he is the owner, and as the person responsible, he is the one we cited by the notice.
I'm aware of that, but
She has no land, she has nothing to put a lien against, and county's policy has been to go forward with the
go where the money
landowner.
is?
So to speak, yes.
So just for the record, I mean, it is my understanding that the county has the ability to go after the actual violators.
Yes.
Okay, that's fine. All right, so how long is the order in effect? Are you able to tell?
2045.
And did they call it temporary?
Yes.
What judge signed it?
Judge Thomas.
Okay. When was it signed, if I may ask?
One moment.
I know you said February 20.
March 25th.
27th.
March 25th, so it's beyond the time to appeal. Temporary for, let me just think about this for a second. Let's go through the presentation, the evidence. I want to know what's happening on the property, okay?
I'm sorry.
I want to know what's happening on the property.
Yeah, me too.
So, actually, Mr. Jonason, have you had contact with the occupant?
I have not.
Okay.
I've not seen anybody there.
Okay. All right, then, sir, I do need to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
I can go through all the pictures if you need me to, but because the weather's changing, it's gotten a little bit better, but it's still overgrown. No, that's the lawn case. No, this is the junk. That's next to your garage.
Oh, man, I can't look no more, man. I'm sorry.
All right,
I can't
then
look at that.
I didn't hear any legal objections. I'll take a look at these documents. Without objection, what's been proposed as Exhibits A and B are admitted in each case. Thank you. So I'm going to just take a, bless you. I'm going to take a moment just to look at this. Was it mowed on the fourth?
I think it's just the weather and it hasn't grown, but it's better in some areas.
Yeah, it's
but
better.
It's still, I didn't get a great picture of the backyard off to the right, but that area is.
Why does it say Walker on the mailbox?
A big pardon?
Why does it say Walker on the mailbox?
I don't know, but Banks is my last name, and it's been on that mailbox for 16.5 years.
All right, let me just show you page 7 of 7.
No, that's the neighbor across the street.
Oh, that's the neighbors.
They
Okay.
have the mailboxes all on the same side of the road for the post office. I have to give him,
Oh, I
permission
see,
to
I
have
see.
his mailbox there.
Okay.
It's just the way it is. But
I got it.
that's a rental property. I never know who was over there, so.
Is there anyone from the public who wants to be heard on either of these cases? Okay, sir, why don't you come on up?
Oh, it's just swear me in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please.
Samuel Banks.
Thank you.
Mr. Banks, would you please speak into the microphone so that the record picks you up? And I'd love to hear what you have to say.
All right. We are going for modification of this ruling. The Billy Joe Powell's had told the judge, had lied to the judge, said she had lived there for 2 years. She'd been there like 6 months. She lied to the judge and said that it was her property when the judge made this ruling. So we've gone to get her, I spent money to get an attorney to get her evicted. Come to find out with this modification, which is on this case, the judge wouldn't do it. So the same judge, now, we go back on November the 4th to have this modification, have it modified, which I'm pretty certain that we'll get it done. This, in the neighborhood, the neighbors coming to me because I live in that neighborhood, and, it's very embarrassing because, my son's always kept that property immaculate. The home is destroyed. It would have sold for $280,000. We're going to sell it. We might get $100,000 out of it if we're lucky. It's that bad. It is that bad. And because of this modification, because of this ruling, which, I'm not blaming the judge because she didn't look into it to see who was on the deed of the property.
Yeah, I've learned the hard way. Be careful what you blame a judge for.
Well, it is what it is. And if a shoe fits, you got to wear it.
That's right.
Okay? But I'm not, I'm not knocking her or anything. Because she didn't know.
That's
see?
right. Yeah.
And, but it's put the family in a predicament.
Let me ask you this. Let's assume, just for the sake of argument,
Okay.
that a right of possession is restored by, let's say, November 15th. Let's
Yeah.
just say.
Yeah.
How much time do you think it would take to clean the property up sufficient to fix these violations? In other words, get the junk off the property or get it inside a garage or something, and just mow get everything below 18 inches.
I tell you what, I promise you it won't take long.
Like a month?
Because we're going to get on it and get it done. This,
We've already agreed.
we're very clean people, and we're ashamed of the property. For
Give
the
me an
neighbors.
estimate.
I feel sorry for the neighbors.
Give me an estimate of how long y'all think it would take.
10 days.
Okay. I don't know. That's pretty impressive if doable.
But if you give me 30 days, or 60 days, whatever you want to give me, but I tell you, we're going to do it as fast as we can, okay?
You never know what a judge is going to do, and you never know what the other party might allege, and I'm not passing on the veracity, by the way, of what anyone's saying in the other cases. I do think that a violation exists in both
violation
respects. Right, and
definitely
y'all aren't
exists.
arguing with that. So what's the county's recommendation?
$50 per day per violation in administrative costs.
All right, I'm going to grant 60 days in each case to bring the property into compliance. And if the property isn't brought into compliance within 60 days in each case, there will be a $50 a day fine. I will also ask that it be put in the order that if a fine ever accrues and or becomes a lien, that the county gives special consideration to the circumstances of possession if there is a request for forgiveness. Okay?
Yeah,
All right, that's it.
that's about fair enough.
Thank you.
Thank you very much.
Appreciate it. Thank you a lot.
Next case, Anton Paul and Sabrina Burdenson, case number 2025-0274. Code Officer Cody McGuire, page 8 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Yeah, I already.
Okay. Oh, this is, okay. All right, welcome back.
Thank you.
Mr. McGuire, please proceed.
Okay. Cody McGuire, Citrus County Code Compliance Officer, case number 2025-00274, Citrus County Land Development Code, Chapter 4, Section 4100, Site Improvement Plan. Address is 285 North Quiet Pines Point in Christian River. It's 4.86 acres and it's zoned CLRMH. The property owner is Anton Paul Brennenson and Sabrina Brennenson. Good service via posting the notice of hearing on the property and posting at the Canto Government Building. And I'd like to authenticate the following documents and request that be admitted into evidence. It's going to be Exhibit A, photos taken during initial inspection on March 4th, 2025. Corrective action inspection on August 25th, 2025. And photos of my final inspection conducted on October 13th, 2025. And then Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the notice of hearing posted on the property, a posting affidavit, and a pre-hearing order.
Can you tell me in narrative form what's happening on the property?
Yes, sir. Mr. Anton, he had brought in quite a large amount of fill in on a flood area and applied for permits later on afterwards.
Is the permit under review?
Yes, sir.
It hasn't been issued yet?
Correct.
Ms. Coutu, I'm curious. I mean, so what's the permit for?
Yes, the permit is for fill, but he's also added, it's for a steel building. The steel building doesn't meet flood requirements, so I do have some concerns on whether that can actually be permitted. I think they'd have to raise it quite a bit. Not worked out yet. That was, the last review was September 19th. So it's been denied and in his hands since then, but I don't know what plans he's got for that. I do have some concerns.
Okay. All right, Mr. Berenson, tell me what's going on.
Okay, so we're working out the issue with the Connex. You gave me, graciously gave me 90 days to make sure that.
I vaguely remember this, yeah.
It was from last time,
Yeah.
and I said that's fine, because I did read the laws, and they did say as long as you have a permit. So I am waiting on 2 revisions. One was from structural engineering, waiting for one little verbiage that I need to do. I came across the opportunity to get dirt. I knew I needed a lot of dirt because FEMA now requires 12 feet above sea level. And that is the reason why I'm at like 3 feet. So I had the great opportunity to get dirt brought, and I know ignorance is not, I didn't know. I said, please bring it. I know I'm going to be building. Can I bring it in here? And he could, fast forward till now, it came to my attention that, hey, you needed a permit for that, and now I did everything that I can to make it look good. It doesn't look bad. There's no impact to neighbors. He can see in the exhibits that you can see it's very planed out. No one would even know it was there unless it was called by my wonderful neighbor. So ultimately, I'm just asking for leniency. If you feel the need that you have to penalize me $2,500 for this, I'm just asking for leniency on it. I did everything I can. I've been very proactive with the county. I've been very proactive with everything that I've been doing. And at most, all I'm asking for now is if you insist on finding me for this. so-
2,500 would be me being lenient, just so you know. The county asks for $5,000 fines normally. I have no idea what they're going to ask for here. My authority goes to 10,000. This doesn't sound like that kind of a case. But what is the county requesting?
One time of 2,500.
Okay. Can I see the pictures?
Sure.
Actually, can you show them to Mr. Berenson first? So I just want to be able to look at these. Let me know if you have any legal objection.
Yeah. Yeah, what's the most recent?
Yesterday's. Right
Yeah.
here.
If you could see how the most recent looks.
All right. I'll take a look at that. Thank you. Let me just quickly scan this. Yeah. I didn't know about the 12-foot requirement.
It's substantial, and it's been very, very trying, so I didn't. And that's why the home is elevated as high as it is, because of new FEMA requirements.
You're building something nice there. I can't fault you for that. Is there anyone from the public who wants to be heard on this case? Mr. Berenson, the problem here is that everyone else gets a $2,500 fine from me on something like this. And I'm not going to make an exception because I do think it looks good. I have to hold the line as a deterrent value for other people doing this. The county is particularly concerned about fill because you can flood your neighboring properties when you raise the level of yours. Does that make sense?
It does, and that's why I had a fill plan engineer that has showed this, and it's been approved already on the fill plan.
Well, that's why everything has to go through the permitting because it can affect the neighbors and lead to that. So this isn't just about you. This is about maintaining the integrity of the law. So I'm going to find that there's a violation and assess the fine. Okay? Good luck.
Next case, William Castillo, case number 2025-1250, Code Officer Cody McGuire, page 10 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Good morning, guys. Good morning, Cody. How you doing, buddy? Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please, sir? Sir, please state your name.
Oh, William Castillo.
Thank you.
Thank you. Mr. Castillo, oh, okay, gotcha. So we skipped a case? Did we have another case before him?
Boone is on the docket, but is nobody present for that one?
Oh, I'm sorry. Okay, I didn't realize we were skipping. Good morning, Mr. Castillo. How are you?
Pretty good, buddy. How you doing?
All right. Please proceed.
Okay. Cody McGuire, Citrus County Code Compliance Officer, case number 2025-01250, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address is 12205 West Bald Eagle Court in Crystal River. It's 0.17 acres in its zone CLR. The owner is William Castillo. Good service via posting and the notice of hearing of the property and posting of the Canto Government Building. And I'd like to authenticate the following documents and request that be admitted into evidence. Exhibit A is photos taken during initial inspection on July 23rd, 2025. Aerial photos from the property appraiser's office dated May 4th, 2024. July 1st, 2025. A corrective action inspection on August 22nd, 2025. And a pre-hearing inspection conducted on October 13th of 2025. And then in Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the continuance letter posted on the property, a posting affidavit, a general pre-hearing order.
What's happening on the property?
Mr. Costello had removed some trees and did some groundwork and a little bit of fill on the property without a permit.
Okay. Mr. Castillo, I may or may not need to look at the photos, but are you contesting whether or not you did these things?
Absolutely. I haven't done any development. Here, let me provide.
Hold on. So before we get to that, we'll get to that then.
Pictures.
I just wanted to know. So, Mr. McGuire, can you show your exhibits first to Mr. Castillo? Mr. Castillo, let me know if you have any objection to these being evidence.
No, I don't.
Okay, and you'll be allowed to present your evidence as well.
Okay. I got a copy on it. Yeah,
And the rest look like that for the most part.
yeah, we know these ones. We know.
Okay, Mr. McGuire, I'll take those exhibits. I'll admit them as, I will wait. Correction, I guess I will wait. Okay? Exhibits A and B are admitted as evidence. And let me just take a look here so I understand where the county is coming from.
Remember, we had 2 hurricanes on August and October last year?
Yeah, Mr. Castillo, if you just give me a moment, I definitely want to know what your defense is, but I just want to look at these photos first. So I even understand what the county's presenting. So, Mr. McGuire, you have provided in Exhibit B, I think, I'm not exactly sure, page 9, I think. Yeah, page, actually, I don't know. You go from, yes, okay, I don't know, I think it's page 9, but it's a copy of a permit application, I think?
Yes, sir. It has not been issued yet.
Okay. But it appears that this would be a request to build a 1,200 square foot house?
And I'm sorry, I'm jumping in, Joanna Cattillo, Land Development. It's just an application. It's
It's an
stuck in
application.
intake. There are no plans attached,
Oh,
so it
okay.
has not moved in any kind of review process. It's still awaiting attachments.
Okay, all right. Do you know when the application was filed?
It was submitted on our system, the application document on September 28th.
Gotcha, okay. So after this case started, which was a couple months ago. All right. Okay, Mr. Castillo, I think I understand what the county's, and I'm sorry, Mr. McGuire, do you have anything else you wanted to say?
No, sir.
Okay, I think I understand. Mr. Castillo, what's going on?
Okay, I would like to, okay, what's going on? There is no development. First, I'm not a developer. I guess the term developer is a person that does that for living, I guess. Says the ordinary course of business. That's not my business. I don't do developing. The development terminology, it refers to a multi-stage process of creating a new property, of adding value to an existing property, which I'm not creating a new property, I'm not putting additional buildings. There is no buildings on it. I have my boat, and I've been using the property for recreational purpose for the past 5-6 years. Until the hurricane came and killed all my grass and killed all the red vegetation, I would like to take this into exhibit. This is the picture that I sent you.
So,
before
Mr.
the hurricane.
McGuire, why don't you and the county take a look at this document? Let me know if you have any.
That's the picture
Mr. Castillo, hold on.
after the hurricane.
Hold on a second. Why don't y'all take a look at this and let me know if you have any objection to it being evidence?
There is the dates. You guys using May 2024, before the 2 hurricanes. The 2 hurricanes, this property is right in front of the bay. It's a waterfront property.
Okay.
So the hurricane
Why don't you,
destroyed
into the
everything.
microphone.
And
They're gonna let me know if they have any objection to it, but of course, I do want to see it.
yes, please.
If we could just inquire of Mr. Castillo as to foundational questions.
Hold on a second. Okay, inquire.
Hi, Mr. Castillo. The photographs that you just handed to the court, it includes 3 photographs. Did you take all 3 of those photographs?
Yes, ma'am, I did.
Did you indicate above each photograph the date that each of those photographs
Yes,
was
ma'am,
taken?
I did.
Did you take those photographs on the date indicated by the date that you added?
Yes, I did.
We have no objection to the questions.
Okay. All right, let me take a look. I'll admit this document as Exhibit C. And let me just take a look here.
The first one is the day after the hurricane. I have mountains of everything that accumulated there. There is no vegetation, there is no trees. It's just the garbage and debris that came from the hurricane.
How big is the property?
7,000 square feet. It's very tiny.
Yeah, it looks bigger in the photos.
Yeah, because of the wide lens on the cellular cameras. The second actually is a different cellular that it did super wide lens. But it's really a tiny property. It just looks bigger on the pictures.
Okay, is there anything else?
Yes, sir. Is there any requirement for fencing?
I don't think fencing is alleged as one of the violations.
It's
Okay.
not.
Yeah,
So is there any permit requirement for planting grass?
I'll take this as, first let me ask Mr. I can make this go a little easier. Is grass a part of the alleged violation?
No, sir.
No.
Okay.
So let's make it clear. What is the county saying Mr. Castillo did wrong?
So long story short, there were a few trees that were removed off the property. There was a large pile of fill that was placed on there and then spread, along with the hay bale, and then he installed the fence. But the fence is not part of the
Fence
violation.
isn't part of the violation. So what they're saying is you did a little bit of site clearing in terms of trees and you put fill in on the property.
I did not. Actually, the sand is called silica sand. It's for planting grass. If the roll of hay, it's not a roll of hay, it's called a roll of straw. And we can go to the Department of Agriculture Extension Office manual, and it says adding perlite or coarse sand to your soil is used to improve drainage and aeration, which is especially important for planting grass in dense, heavily clay soil. I mean, it's a long paragraph. It improves aeration, enhances drainage, it causes neutral pH, lightweight. Okay, about the straw. Actually, the state of Florida best water management practices recommend the use of the straw to maintain humidity, moist retention, soil stabilization, temperature regulation, protection from birds, and it adds organic matter for planting grass. The 2 tons of sand that you see there is called silica sand. It's used to give a little bit of moist to the grass since it wasn't growing. I have planted in January and March, we planted grass and it didn't grow. Back on June, we did it again. And then we had to add the straw and the silica sand. But there is no field. As you can see on the first picture, there is no difference on the level of the ground or consistency. The only difference is that we drove equipment and killed the grass that was there, but it probably the salt water killed it. And then we've been trying to replant the grass. Some of it is growing, some of it is not growing, but we have not had any field, nor had needed, because the property is about 3 feet, about 3.7 feet above sea level, so it doesn't require any field.
Mr. McGuire, is there a requirement that Mr. Castillo obtain a permit for silica sand when used as he's proposed?
I was unable to find anything. Yes. There was? I'm sorry.
Ms. Katu, what do you think?
It falls under the definition of development, regardless of the sand versus hay versus straw versus whatever.
So if he's resodding and he's resodding with this sand, he needs a permit?
It's falling under the definition of development. This is a vacant site, so we really shouldn't have anything happening here until there is actually a principal structure involved.
It's not my question. You know, if it's a vacant site and someone decides that they want to resod, are they allowed to do that without a permit?
In that general area, most likely, yeah.
I think so too. So my question is now let's move to the next step. If they're allowed to resod a vacant parcel, doesn't that necessarily involve, or sometimes doesn't that involve adding dirt with the sod?
In this case, it's a flood zone, so we would want to have some kind of flood review if you're adding fill, not necessarily just sod. You're going a little beyond that because this is a flood zone, as you saw in the pictures. That's a concern.
I know it's a concern. I'm trying to figure out, because it's one of these things that's like,
yeah, I understand.
is this overkill or is it not? So let me address Mr. Castillo first. So you brought up the point about you're not being a developer, and that is not relevant for whether or not development has been done. I understand that basically the development under the Citrus County Code is construed very broadly. So, and what you're hearing is an argument from the county that essentially if you move anything on the property, if you do anything on the property, if you change it in any way, the county is going to hold the position that that constitutes development. You need to ask them first. And so what I'm trying to get at is, at what point are you able to do something on the property without asking the county? Or at what point is it not actually development? I'm not talking about the trees right now. I'm just talking about the sand, the silica sand.
It's only 2 tons. It's a very small amount. The angle makes it look a lot bigger, but it's just a very small amount. It's a pickup truck back load.
Well, I do see a pile, like I do see a mound, and that wasn't there before. Like there's a mound of it, right? So in the past, I have held that to be a violation, just so you know. Because it looks like you're trying to do something on the property and probably trying to do something good with the property, and probably everyone wants that. But the issue is whether or not you have to talk to the county about it. So let's talk about the trees. Under the photos, it definitely appears like there was some hurricane damage and that it knocked down some trees. Is that right?
Yes, and all we did was clean it and put it on front, and it was taken by the county.
Did you take anything else out when you cleaned the
Nope.
property?
Absolutely no. The only thing I pulled was an old boat that was sunken on the canal, and we pulled it. You can see it there. The other boat that you see is my boat that I have been using for the past 5 years in and out of the water. We have camped there for 5 years whenever we use the property, and we had done a recreational use of the property since 2020.
So it's important to know that because this is vacant, you're not allowed to do anything else with it, including camping, until the primary use has been established. So just so you know, in the future. Does that make sense to you?
Not really, because there is certain inalienable rights for the property owner, such as paid taxes, access to his property, recreational use. I was aware that I cannot leave the boat.
Inalienable rights? Did you say that?
Yeah, I mean,
so there's
certain,
an inalienable
certain
right.
rights or
I want to
certain
make sure I
rights.
understand. There's an inalienable right to recreational use. Where is that
No,
in
no,
the?
no, actually,
Well, no,
it's
where
not
is
an
that in the
inalienable right. There is
Constitution?
certain rights. I'm
Sir,
sorry.
I'm speaking.
Yes,
okay.
sir.
Yeah. all
Yes, sir.
So where is that in the Constitution of the United
I-
States? I'm not going to say this again. I'm speaking. Where is that in the Constitution of the United States or the Florida Constitution?
It's not.
It's not.
It's
No,
case.
I think I get your point, which is, property owners do have rights. They should have rights.
Yes, sir.
But once a hearing, I have to do this.
I know.
Okay.
I
So,
understand.
so here's the issue. The county's always taken the position, and I've always upheld it, that because of what it says in the code, you really can't do anything else on a residential piece of property. I assume it's residential. You gave me the zoning on this? CLR?
yes, sir.
CLRMH. Until the primary use is established. And it looks like you're trying to do that, right? So you filed an application, correct, for a permit?
Yes, I did.
Okay. Is it your intention to build a home?
It wasn't at the moment that we have our first encounter, but we agreed to clear the problem by just requesting an application. So I ended up deciding to build a 1,200 square foot house, which we use actually pre-approved over 1,500 times master plan, and there were additional. I mean, there is discrepancies between what to use to submit the permit on the website. Then you go to the county to submit it, and they give you an additional bundle of requirements, which is actually missing additionals that were given to me after submitting the application. But all documents have been submitted. I had two architects and 3 engineers working on it. In case there is anything, it's already paid for. They already did the plans. We have more plans than the ones they even managed to ask us.
Let me ask this. Is there anyone from the public here to speak on this case? All right. What is the county's recommendation?
A one-time fine of $5,000.
I won't do that. So I actually think that you are correct, Mr. Castillo, about the trees. I think your evidence is persuasive about that. But I think you have conceded to whether you think it qualifies as fill or not. I think it does qualify. I know it when I see it in the photos, and it may be a good type of soil. It may be exactly what you need on the property. It may be the soil the county wants on the property. But you have to talk to the county about it before you bring it in and before you roll it over your property. It's what the county requires. It's development under this code section. And this is for the viewers too, I mean, if you want to change this, you have to ask your county commission to amend LDC 4002A. So I'm not going to assess that fine. On the last case, I think that was a lot more. It was also on a bigger piece of property, and it was a fine of $2,500. In this case, I'll assess a fine of $1,500. And good luck, Mr. Castillo.
Okay. Can I, okay. Yes, sir.
And by the way, if you disagree, you can appeal my order.
Correct. Thank you, buddy. Appreciate it.
Next case, Brian Dunlop and Emily Perez. Case number 2025-1692, Code Officer Robert Denaro, page 11 of your agenda.
Not trying to give you work, by the way, by inciting appeals, but Mr. Landon, I did see at least one yawn, so we're on the clock here. I'm going to keep the counter going. Yeah. I'm going to start if you guys start, so.
I do. Brian Dunlop.
Good morning, sir.
Good morning.
Good morning.
All right.
Which case was it?
This is case 2025-1692.
Okay,
And I presume 1693.
that is correct.
Okay.
They're repeats.
They're both repeats?
Yep.
Okay.
Good morning, everyone. Robert Denaro, Citrus County Code Compliance Officer. This is a repeat violation initially observed on September 18, 2025. The address is in violation is 5555 South Bluegill Way, Floral City, Florida. Case number CE 2025-01692, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 2031A of the Citrus County Code of Ordinances. The property is owned by Brian Dunlap and Emily Perez, have previously been found guilty of the same violation on December 26, 2023, CE 2023-0649, with 0 imposed fines and administrative costs, and the case was abated on April 3rd, 2024. Good service via posting of the property and posting of the Lecanto building and signed certified receipt returned mail. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, finding of facts, order acknowledging compliance from previous case, CE 2023-0649. Exhibit B, photos taken in the initial inspection on September 18th, 2025. And I took subsequent photos of the inspection on September 24th, October 1st, October 7th, and my final inspection on October 14th, 2025. Exhibit C, a copy of the repeat violation and hearing sent to Brian Dunlop and Emily Perez, a photo of the notice of violation and hearing posted on the property, a copy of the general pre-hearing order, and a copy of the posting affidavit. This property is 0.27 acres and is owned CLR. I conducted my initial inspection on September 18, 2025. Oh, excuse me, I'm sorry.
Well, so, sir, you're going to be asked to look at these documents.
Okay.
Yeah, and let me know if you have any legal objection to them.
And then, of course, the postings.
Yes.
Yeah. These all look to be my place. It is. Yeah. Yeah.
All right, so you don't have any objection to them being evidence in this case?
No.
Okay.
No, not at all, unfortunately.
Did he ever see these? You hand them back to me, Robert.
Yeah, I got it. Yes.
I know you did, that's why I asked the question. Now hand both to Christian.
Thank you.
Thank you, sir.
All right, so what's been proposed as, I think, Exhibits A, B, and C are admitted as evidence, and I'm just going to quickly look through them. Okay, and it looks like the reason I gave so much time on the prior case was that you had testified before that you were unable to access the property. That was in the
Yes.
prior case.
Yes.
So what's going on here?
It started off with my mess with, again, is I had trees fall down and crushed a bunch of vehicles and boats, which I'm trying to get removed. And then, honestly, the past 2 months, I was injured and haven't been able to cut grass or do anything, so the grass has gotten out of hand. But I have people from the community and my church actually there today, cutting grass and removing the debris.
The problem is that because it's a repeat violation, there's going to be a fine running from the day, you know. You understand? Okay, all right, please proceed with your case.
This property is 0.27 acres and is zoned CLR. I conducted an initial inspection on September 18, 2025. Excessive vegetative matter, loose trash, plastic containers along with miscellaneous junk and debris. I posted a notice, I posted a repeat notice of violation and hearing at the property on September 18, 2025. I conducted follow-up inspections on September 24th, October 1st, October 7th, and my final inspection on October 14, 2025. And the property has been found in violation, and I've had contact with the owner. Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 a day along with administrative costs on the date of posting on the property from September 18, 2025, and then continued to October 14th, 2025. That would be 26 days at $150 a day, totaling $3,900, and a fine of $250 a day from this day forward until the violation is abated. We would like to ask the special master to find that the respondent's responsibility to notify the County Code Compliance Division when the violation has been abated for a follow-up reinspection.
Is there anyone for the public who wants to be heard on this case? Mr. Dunlop, is there anything else you want to say about this?
I would like to get it under control, and I'm working on that now. If I just, as soon as
I believe that. However, this
my
is
second time. I
It
understand.
actually is a fairly low ask from the county. I mean, they normally go higher on the repeat fines. So I'm inclined to adopt the county's proposal. So I am going to find that there's a violation, that it's a repeat violation. I did review the prior order signed by me. I was wondering why I'd given so much time. In any event, it's going to run $150 a day from the day of first posting until October 14th, and it will run $250 a day from today's day forward. So, and that's the first case.
Next
All right.
case, is Brian and Dunlop, Emily Perez, case number 2025-1693, Code Officer Robert DeNaro.
Robert DeNaro, Citrus County Code Compliance Officer. This is a repeat violation initially observed on September 18, 2025. The address in violation is 55555 South Bluegill Way, Floral City, Florida. Case number CE 2025-01693. Unlicensed inoperable vehicle in violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The property owners, Brian and Emily Perez, have previously been found guilty in the same violation in the same location on December 26, 2023, case number CE 2023-0650 with $0 imposed fines and administrative costs. The case was abated on April 3rd, 2024. Good service via posting on property, posting at the Locanto Government Building, and signed certified receipt returned mail. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, findings of facts, and order acknowledging compliance from the previous case, CE 2023-0650. Exhibit B, photos taken at the initial inspection on September 18, 2025, and the photos I took during my subsequent inspections on the 24th of September, October 1st, and my final inspection on October 14, 2025.
Okay, can you please show these documents again to Mr. Dunlop?
Same thing. This is the findings of fact from the previous case. This was what was posted at your house. And of course, this is, you could look through the same, they're basically the same photos. Okay.
Let me know if you have any objection, Mr. Dunlop, to them
No.
being evidence in this hearing. And
No, I got it. I was, like I said, it got out of hand with everything, and then at my accident, I was in the hospital for a month, and I haven't been able to do nothing with it. But we're there now.
if this had been the first time, I'd be
I
able to factor
understand.
that in. The law requires that I do this, but in any event, all right. So let me take a look at the exhibits. And is there anyone from the public who wants to be heard on this case? All right. So. All right, exhibits A, B, and C are admitted as evidence. I'm just going to take a quick look. This exhibit A looks, they did print wrong. I don't know if y'all saw that, but so the first page of my order printed fine, but the second page only printed a corner. Yeah, so I don't know, just something to, I can tell it's my writing. I can tell it's, you know.
Thank you.
How many unlicensed vehicles or improper?
There were, I think there's two actual, like, there's two, like, I think Broncos, and I think there's like 6 boats.
My personal, and there's 3 boats.
3 boats, sorry,
Yeah.
sorry.
I mean,
That were crushed by trees that I'm trying to get rid of from the storm.
okay,
Well, 2 of them were.
that's what I was gonna ask.
The Bronco is to our vehicle that we bought to replace from my accident,
Mhm.
and it's just not able to get going yet.
Yeah.
But that's what the Broncos are there
That's
for.
the
2
Bronco.
Broncos, yeah.
Yeah.
They're brought there after
Oh, I
this
see 2 of
even.
them, yeah.
Yeah. Right as my accident happened is when you guys said, well, when he had come out for inspections, is like literally I was admitted from, it was the 8/14 to 8/21, and then I was in and out. I had been in and out for the last 2 months.
I'm sorry to hear that. What's the county's recommendation?
Citrus County Code Compliance Division respectfully request that the special master assess a fine of $150 a day along with the administrative cost to begin on the date of the posting of the property, September 18, 2025, and to continue till October 14, 2025. That would be 26 days of $150, totaling $3,900. and a fine of $250 from that day forward until the violation is abated. We would also ask the special master to find that the respondent's responsibility to notify the County Code Compliance Division when the violation has been abated in regards to allow for reinspection. Excuse me.
Okay. In light of the mitigating circumstances, I'll assess a $100 a day fine from the date of posting instead of $150 up until October 14th, and then $250 from today's date forward. And that's it. Okay.
Right.
Now, Mr. Charlton, I have to call back up the Novich case. I'm sorry. Yep, I made a mistake. Case number 25-1388. All right, so here's the mistake I made. The mistake I made was I was realizing if I believe that Mr. Novich didn't have an actual, proper opportunity to appear, and I do find that, then I have to give him an opportunity to be heard. Mostly, I did find a violation, but I think he has to have a right to be heard. I can't say that Ms. Riley stands in his shoes, even though she has standing to appear herself. So I'm going to continue the hearing. I'm going to reserve ruling, although that's my intention, is to find a violation for the two reasons I put on the record. But I have to continue the hearing to give him an opportunity to be heard on that.
And we can notify him that.
You understand what I want?
Yes, sir.
All right, thanks.
Thank you. Next case, Joseph and Cynthia Lynn Charette, case number 2025-1339. Code Officer Alan Jonason, page 35 of your agenda. Expert on the case, Land Development Director Joanna Katu.
And I'm sorry, what page of my agenda? 35. Okay, thanks.
Hi. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do. Please state your name. Cynthia Charette. Thank you.
Good morning, ma'am.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-01339, special requirements for all accessory structures. A violation of Citrus County Land Development Code 3102. Address of the violation is 3184 East Porter Street, Inverness, Florida. Property owners Charette Joseph Allen and Charette Cynthia Lynn. This property is roughly 0.44 acres and is zoned MDR and was purchased on 2 May 2022. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 7 August 2025, photos from my compliance inspection on 8 September 2025, and photos from my final inspection conducted on 14 October 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing notice.
Okay, ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection. Are you contesting whether or not there's a violation?
Oh, no, I know there's a violation. Okay.
Well, okay. I mean, how much time do you need to fix it?
Well, actually, I would like to explain my situation.
Sure, okay,
This property is jointly owned by my ex-husband and I.
okay.
Can I have a copy of this?
You can request one.
Okay.
And ma'am, if you would speak into the microphone.
The property is jointly owned by my ex-husband and I.
Right.
And our divorce was finalized March of '24.
Okay.
He had 1 year from the date of that filing to clear the property and pay me $20,000. He hasn't done any of that, and he's left. It's just not, it looks junky, but there's also an excavator with, I'm going to have to get a starter for, but it's not my property. And I have filed, I'm operating pro se, I've filed a motion I reopened the case, and I filed a motion for contempt and for enforcement, judicial award of property and declaration of abandonment with with telephonic appearance. I live 5 hours away now
Where do you live?
in Marianna, Florida.
Yeah.
I tried to stay here, but my ex-husband negated every effort I could find to rent. He would trash me to the.
So you're asking to, in your motion, and I assume it's here in Citrus County? the
Yes.
divorce? Are you asking for full ownership or just to enforce the agreement so that you're bought out, or what are you actually asking?
I'm asking because he is in a rehab facility.
No, what are you asking? Are you asking to become the full owner?
I'm asking for it to be declared abandoned and that the judge award me the property so that I can dispense with it.
You'd be the sole owner.
Right, so that I can do something with it, sell it, get it off the property, and
Okay.
then I can sell the property.
Okay.
And you want me to, I can submit my motion and stuff to,
No, I mean, I can, that's fine.
it's already been filed with the court.
But I do think you're at least a 50% owner. You could become a
Yes.
100% owner soon.
I don't know.
And, you do have the right to clear the property as a co-owner. Does that
I
make sense?
do?
Yeah, of course. You have as
Even
much,
though it's not
you have
my
as much-
property?
How is it not your property?
It's
No, but the
in
deed is
in the decree, it declared that it's his property.
But the deed, I understand. In other words, you should have been bought out. He should have paid you $20,000, correct?
Yes.
Hasn't happened. So without some kind of effectuating document such as a deed, that's the magic thing that divests you of ownership and goes to the other person. And now judicial order matters, but it has to be complied with, as you know.
Right.
So I'm kind of splitting hairs. I just want you to understand that, you do have a right to clear it as it stands today. And if you are asking to become the full owner, why wouldn't you,
Yes.
All right, so here's what I want to know. Do you have a hearing set on the motion?
It took me a month to get him served. He's furious. He's in a rehab facility and is threatening me. If I can legally,
I encourage you to retain your own legal counsel. I'm not your lawyer.
I'm pro se. I don't have money. I've already spent all my money trying to.
Well, sometimes there's, sometimes there's legal aid type organizations, community legal services of Community Legal Services of Florida, Mid-Florida. My only point is, I can't give you legal advice, but it appears to me that you are a co-owner of the property, okay? And you're here. I think you were properly noticed, that kind of
Yes.
thing. So I understand what you're doing. Now let's say that let's just assume for the second that you do have the right to do as you wish on the property. How much time do you think you'd need to clean it up?
I need to get a starter for that. It's not just junk. It's an excavator. It's a travel trailer. I'm going to have moved. There's a greenhouse. And there's vehicles that I don't know if they run or not. I'm assuming not.
I think Mr. Jonasson said it's 0.44 acres, something like
Yes, sir.
that. Okay.
There's 2 lots together that we own. If I'm able to move it and they're going to say I can surely move it, but I don't want to do, Citrus County has not been kind to me. I want to be very careful in what I do because he has not followed any of the court orders. I didn't get my visitation with my daughter, and I didn't get the court-ordered counseling, and he has estranged my daughter from me to the point that it's been a horrific divorce, and she's 18 now. For the first time in 3 years, she called me and was kind. Things are looking up, but I desperately want to resolve this. And I know that they have to give 30 days once he's notified, and I did subpoena documentation to prove that he did have funds to pay me and refuses.
Well, I'm going to cut to the chase.
Okay.
I'm going to find that there's a violation, okay? So the only question is how much time I give to bring the property into compliance. And that's why I'm asking you about time. First, let me ask is there anyone from the public who's here to speak on this case? I don't see anyone.
And I would like to plead mercy.
You know, there's not a lot of, there's no whips here, you know. So I think what I'm going to do is, what's the county's recommendation, first of all?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Have you had any contact with?
I have spoken to her, yes.
Just her, okay.
Absolutely.
I told him what was going on.
Yeah, sure. All right, well, then I will find that a violation exists. I am going to grant, yeah, go ahead.
I'm sorry. They're gonna give him at least 30 days for him, once he's received all to discover and all that. And then once if they go see my favor, then I'll have to have time to get somebody and either get a low boy to remove the excavator or get the starter
I
fixed.
understand all that.
Okay, I'm sorry.
All right, so I'm gonna find that a violation exists, and I am going to grant 120 days to abate the violation. If it's not brought into compliance within 120 days, there will be a $150 a day fine. I will also make a request in the order that the circumstances of possession be considered if there's ever a need for lien forgiveness. Okay?
Okay, is there any way we can associate this case with the divorce case with this case so that?
No.
No?
But you could bring it up in your case. I mean, I'm not your lawyer, but of course, if I was the judge, I would want to know about everything that's happening, so.
Okay. And I'm sorry, I'm ignorant of all these things. Is this going to be filed anywhere?
I will sign an order. It will become a public record. I don't know does the county automatically record my orders? Okay. So it'll be recorded in the public records, so it won't be hard to find. We will deliver you a copy.
Okay, and I can file that notice to the court?
Of course. Okay.
And
good
how
luck.
long?
I gave 120 days.
Thank you.
Next case is Thomas Smell, case numbers 2025-1193, 2025-1194, and 2025-1227, Code Officer Erica Olson.
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Thank you.
Please state your name.
Thomas Smell.
Thank you.
Good morning, sir.
Good morning, sir. How are you doing?
Well, you get the award for today because you have the most cases of anybody. So there's a couple people have 2, but you have 3.
I have a letter, too.
Okay, all right. Please proceed.
Good morning, Erica Olson, Citrus County Code Compliance Officer. Case number CE 2025-01193 is a repeat violation for accumulation of junk and debris. Violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of the Citrus County Code of Ordinances. This, like I said, it's a repeat violation for case number 2155730 that had $0 in imposed fines. Case number CE 2025-01227 is for unlicensed and inoperable vehicles. Violation of Chapter 20, Article 4, Section 20, TAC 41 of the Citrus County Code of Ordinances. And 2025-1194 is a violation of the Citrus County Land Development Code 3150, fences, hedges, and walls.
So the only repeat is the first one?
Yes, sir.
Okay.
The address is 1479 West High Acres Street. It's approximately 1.18 acres in zone RURMH. Property owner is Thomas Mill. I have good service via certified mail return receipt, and then I did post the repeat case. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A for the junk case 01193 is the findings of fact for the previous junk case 2155730. Exhibit B, photos taken during my initial inspection on the 18th of July, my subsequent inspections on the 30th of July, 25th of August, 24th of September, and photos of my final inspection on the 13th of October. Exhibit C is the notice of violation, the notice of hearing, copy of the general pre-hearing order, copy of the posting affidavit for the case, a letter of continuance, and the certified mail return receipt. For the other two cases that are not repeats, Exhibit A will be
The photos, and Exhibit B will be the notices and related service
As
information.
usual, yes.
Okay, okay.
Okay.
Can you tell me in narrative form what's going on?
Yes, so we got a complaint for the junk. I went out there, I did an inspection. There was boat parts and car parts and spare metal and wood, a lot of miscellaneous items. You could see it from the road at the front yard. I did talk to the tenant on that day, let him know about the violation. I also let him know that there were unlicensed vehicles, which was a violation, and the fence was an issue as well.
What's the problem with the fence?
It's not an approved material.
So it's not the height, it's the material.
There is an issue with height at the back of the property, but I didn't observe that on my initial inspection.
So what is the county's case then? How can it be abated?
They would have to build a fence out of approved material and ensure that all fencing is within the height requirements.
All right, so you are, and you believe you have evidence, whether based on visual inspection or otherwise, that the fence exceeds, is it 6 feet?
Yes, sir.
In at least one portion?
Yes, sir.
Okay, and have you personally witnessed that?
Yes, sir.
And you have photos of it?
Yes, sir.
All right. Before we get into the exhibits, Mr. Smale, tell me what's going on.
I hired an attorney, Mr. Grant. He wrote a letter for you.
The Mr. Grant?
Yes.
Okay.
He asked me to give you this letter that he wrote.
Can you show it to Ms. Olson, who will, I hope, share it with the county attorney? And
Perry Mason was
normally
busy.
I hear from him one way or the other, you know. He knows how to get to me.
This was all done last night.
Okay. All right, so I'll take a look at it. Let's see. So I'll represent for the record. I'm holding a letter dated October 14th, 2025, in regards to continuation of code enforcement hearings on all three cases. Dear Special Master Waugh, our firm has agreed to represent Thomas Smale if a continuation is granted until January 2026. The purpose of the length of the continuance is to file and remove the current tenants responsible for the code issues before the tribunal. As the Special Master is aware, the filing and response time for the current occupant and subsequent removal of the same puts the matter into January 2026, which allows time to bring the property into compliance. Thank you. Sincerely, Brianna Rosa. All right, I'll admit this as evidence. I should admit your stuff as evidence too. Can you show your documents to Mr. Smale and let me know, Mr. Smale, if you have any objection to the documents you're about to see being evidence?
Let me unclip them for you.
Yeah, it's going to be quite a bit. So it's going to be 3 exhibits on case number 25-1193. That's the repeat.
Right.
This is the repeat. This is the previous case. This is photos.
Ms. Harrison, do you have any reason to believe this isn't an accurate letter?
No, Your Honor, we would have just requested each video
Yeah.
as a motion to continue.
Okay.
And when the court's ready to address it.
All right.
This is for the unlicensed vehicle case, photos, and then all the documentation that you received.
Okay.
I do find it interesting
That's good.
that the attorney's name is misspelled on the document.
Really?
I figured all of
Maybe
that
I'll-
would go to weight. There's also no letterhead. I don't believe.
Yeah, there's no
It's-
letterhead.
so
It's a
there's-
very odd
It's an odd
letter. But it does say who it's, in other words, it appears that it was drafted by office staff on behalf of the attorney. When did you get this, Mr.
Last
Smith?
night. Last night.
Was it delivered to you last night?
No, I was in his office at 3:30.
Okay. Okay. Just for the record, I shouldn't have to wait to get exhibits when they've been introduced. They should come to me for my review, just FYI. In other words, this is a process that should take place before the hearing.
Reorganizing them?
Oh, okay. Well, they've all been going and I've been waiting. Sorry, yeah, I agree. No, thank you. Thank you for reorganizing. In the meantime, I'd like to put in a call to Mr. Grant's office. So let me just see here. And by the way, it's not because is it your intention to retain Mr. Grant's office to represent you?
Yes, I already
Okay.
gave her.
Yeah. I'm just a little concerned. It's a bizarre document. Certainly competent counsel. I don't begrudge you. Let's see. Yeah, the name is spelled correctly at the top of the letterhead, but it's not spelled correctly at the bottom. But, all right, so let me think about this. There's a motion to continue all three. It is a repeat. Here's my concern for you, Mr. Smale.
Yes, sir.
If I grant the motion, it is possible that you may bring two of the cases into compliance by the time of the hearing. It may be that you bring all three in, but on the repeat, that's already a fait accompli. In other words, when I have a repeat case, I assess a fine from the date of the violation, or at least from its posting until today, and then from today's date forward. So this letter isn't exactly correct that everything will have gone away by January 2026. There's going to be an issue on the repeat case. Does the county have any, actually, why don't I look at the photos and take a look at what's going on the property before I rule? Do you have a tenant on the property?
Well, it was they were buying it from me.
Okay.
So it was
bought.
it wasn't paid for
Okay.
completely.
All right. Let's see. Okay. Just need to look at some of these real quick. I do remember this. Sometimes I need to review the order. Does the county have a pressing health, safety, sanitary concern?
No, I haven't received any.
What's the county's position on the motion?
We would defer to Your Honor as to the continuance. However, as to the repeat, even if it's brought into compliance, it's going to continue to run until that time.
Yeah, I don't. Does that make sense to you, Mr. Smale? In other words, whether it's continued or not, I'm going to be looking at the same evidence. But it appears that you have retained legal counsel. I just don't know why I would.
I just can't go in there myself and clean it up.
I just don't know why I would continue it to January. I'm not willing to do that. I am willing to continue it to next month. And I mean, as as is always the case when either there's where there's a possession issue, I'm not going to get into the weeds on who has the right of possession. I think that people need to try and bring it into compliance in the meantime regardless. But I will continue the 3 cases to next month. When is the next hearing? It's November 19th? Are we running up against Thanksgiving or anything, or is that in the clear? Okay. Is there any objection to that? I mean, no? All right, then I'm going to continue all 3 of these cases pursuant to the motion to continue, not to January, but to the November 19th hearing.
Okay.
Okay? Thank you.
Thank you.
Next case, Horizon Land Capital LLC, case number 2025-1318. Code Officer Robert DeNaro, page 16 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
I do.
Please state your name.
My name is Scott Bolin,
Thank you. Can you spell that?
Bowlin.
Good morning, sir.
Good morning. How are you?
I'm good. And so you're here on the Hardy case? Horizon. Are
Horizon.
you an owner or representative of Horizon Land Capital LLC?
I am.
Okay. All right. Thank you. Please proceed.
Good morning again. Robert DeNaro, Citrus County Code Compliance Officer. This is case number 2025-01318, violation of Citrus County Land Development Code Section 4002, site development without development order or permit. Anyway, the address is 806 Spruce Street, Inverness, Florida, property owner, Horizon Land Capital LLC. Good service, signed, certified, return receipt, and posting at the Lecanto government building. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos I took during my initial inspection on August 4th, 2025, and photos from the corrective action inspection conducted on August 12th, 2025, and photos from my final inspection on October 13th, 2025. I also produced a aerial photo of the property from the Citrus County Property Appraisers website dated June 25th, 2025, prior to the clearing. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-order, and a copy of the signed certified return receipt.
Okay. Can you please show the documents, please? And sir, let me know if you have any objection to them being evidence.
I have a question about one of these.
Go ahead.
The initial notice of violation was not sent certified?
Okay. What's your question?
No.
No. You don't have to answer
I'm sorry,
anything.
the question is, was the original notice of violation sent through certified mail?
What would it matter?
I never received it.
Okay, so if you didn't receive it, that's relevant. But we'll get into that.
Okay.
I'll say that normally, when someone appears at the hearing, I'm not that concerned about whether it's received. I'm not belittling that. I'm just saying that the point is to have notice for today.
Right.
Yeah, so we'll talk about it.
Okay. Then, no, I don't object.
All right. Sure. It does say service type certified mail, so we'll take a look at the exhibits. All right, so what's been proposed as exhibits A and B are evidence, and I will go ahead and take a look at exhibit B. Mr. DeNaro, do you know off the top of your head if it was sent certified?
Well, I have a signed certified mail return receipt regarding the notice of hearing, so.
Yeah, well, I mean, I think that's the question. So let me just take a look. Is that in my exhibit B?
It should be there, I think.
Yep. So it was sent certified. Let me see if I. Well, let's see here. I see 1, 2, 3, 4 receipts. 2 of them, maybe they're just copies of each other, but
I believe one gets sent to the registered agent, and the other one gets sent to the corporation. So that's the reason why you might be seeing 4 of them.
okay. Well, there's 2 that are dated, date produced August 25th, 2025. They're signed for at here, or not here, LaCanto, yeah, the government building. And then there's 2 that are dated September 8th that are addressed to P.O. Box 274 in Coleman, and they were signed for. And it appears that that's where the registered agent address is for this LLC.
Yes, can I clarify what I was
Sure.
questioning?
Yeah.
The dates of those certifications are after the expiration date of the notice.
I see.
So I didn't get the original notice, which gave
I
me
see.
no time to react to it.
Well, that's fair enough, and that's why the law requires me to give you a time to comply before anything would begin, but that's relevant. So, all right, please proceed, Mr. Gennaro.
Thank you, sir. This property is a vacant lot. It's .11 acres and is zoned medium-density residential. I conducted my initial inspection on August 4th, 2025, and observed that the property has been modified. The property has been clear-cut of all trees and was also graded. While researching the property, I observed that no permits were applied for or issued.
Well, correction, there is no way to abate this. So this is one of those cases where the county, it's irreparable because it can't be undone per se. Does that make sense?
I understand what you're saying, and that was a question I also had, was the letter said to either, to come into compliance. It basically, there's no remedy for what they asked for compliance is impossible to do.
I think we could argue that. I mean, I think actually there is, which is to get a permit. In other words, if you got a permit for what you're doing and you'd end up in the same place, then it is what it is. But the position that's taken is that it is irreparable and that we don't want to incentivize people or to give people a way out of the permitting process. They have to go get a permit when they clear it. I mean, did you clear the property?
The property was cleared, yes.
Yeah.
The question, if I may. Before we purchased the property, we contacted the building department because I'm a building contractor. I'm state certified. And we asked all the questions about permitting, impact fees, water, sewer setbacks, flood zones, to verify that the lot was buildable. Because it's in a neighborhood, but that doesn't mean that specific lot's buildable.
Right.
And the question of clearing never came up. Where we come from, if you buy a piece of property, you can do whatever you want with it. You don't have to get a permit. And then after we found out this mistake had been made, because we didn't intend to come in here and make mistakes, we intended to come in here and do business with the county, there's no permit to clear a piece of property. You can't get a permit to clear a piece of property, which we wouldn't have done it if we didn't know. You're required to have a permit, but you can't get a permit.
Have you called the county about this since you found out about the case?
I called the county multiple times, and I emailed, I believe it was her, asking for clarification on whether or not there was an existing parcel plan, because it is in a neighborhood, and I didn't get a response to it. So, and the county said, the people I spoke to at the county said they had no idea how to issue a permit without a building permit.
I mean, what I'll say is, yeah, we are familiar. There are counties that certain levels of clearing you don't need permits for in Citrus County. Every county has its own laws. And I assume you've been here since the beginning, and there have been other cases where
Yes.
people have cleared, so that's typically how they go. Ms. Katu, do you recall ever getting an email about this? I know you're a popular person. but-
Yeah, no, I don't. I would have answered, you need a primary structure on the site.
I'm sorry, I can't 100% say it was her.
Yeah, no, that's fair. No,
it's just the
and
name
I'm not
Joanna
saying anyone's
sounds
lying.
familiar.
It's fine, yeah, I wouldn't ignore it.
No, I was just curious if you did.
No.
And, all right, that's all I had. All right. I understand your situation. Is there anyone from the public who wants to be heard on this case? What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master to assess a one-time fine of $5,000 along with administrative costs and required to obtain a developed order or permit for the property. The amount was based on the actions of the property owners once they were advised of the violation.
I'm sorry, sir. On these cases, I do assess a fine of $2,500. So that's what I'm going to do.
What about the remedy? I mean, is the fine one time only? And
It is a one-time only.
And then there's no way for me to apply for a permit because we weren't ever going to build
No, there
a
is
house
a
on it.
way. I mean, you can apply for whatever permits you need to build on the property, but it doesn't
If we-
undo the fact that you cleared the property without the proper permit.
No, I understand that, and I agree with that. I'm saying, like, is there compliance required going forward?
Yes, you should always comply with the county code.
No, I mean, in this particular case.
No, it's a one-time fine.
Okay. Okay.
Yep. All right. Good luck.
Thank you. Appreciate it.
Thank you.
Next two cases, Danielle Marie Johnson, case number 2025-1247 and 2025-1320. Code Officer Erica Olson, page 17 and 18 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your name.
Danielle Johnson.
Good morning, ma'am.
Good morning.
And just before we get into it, are you contesting whether or not there's a violation in these cases?
Not contesting, I understand. I just need more, I'm curious. I need more information.
That's fine.
I mean, I
That's-
fixed the
that's
first one.
absolutely fine.
Yeah.
All right, please proceed.
This is case number CE 2025-01247, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of the Citrus County Code of Ordinances. And case number CE 2025-01247, violation of Land Development Code 3102, Echo, special requirements for all accessory uses. The address is 6264 West Holiday Street in Homosassa, Florida. 2.44 acres, zone MDR-MH. Property owner is Danielle Marie Johnson. I have good service via signed certified mail return receipt. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 31st of July, 2025, photos of my corrective action inspection on the 25th of August, and photos of my final inspection on the 13th of October. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the certified mail return receipt.
Okay, ma'am, I'd like to ask you to take a look at these documents and let me know if you have any legal objection to them being evidence.
Yes. These are the same pictures pretty much I have.
Pretty much.
Mhm. And this was because a neighbor didn't like looking at this. That was the first.
We'll get into
was the
that. I
first
mean,
one.
I just
Oh,
need
no,
to know if you
it's
have.
the same pictures.
I
that
just need to know if you have objection to
Oh,
them
no,
being
not at all.
evidence.
No, not at all. Yeah. Yeah, they are.
All right, without legal objection, what's proposed as exhibits A and B are evidence. And I'm just going to quickly look through them. Okay. Okay, I think I understand that case. Let me look at the other case. All right, please proceed, Ms. Olson.
On the 31st of July of 2025, I conducted an inspection in response to a complaint regarding junk on the property. During my inspection, I observed a shipping container, and built off that shipping container was a carport type structure. Under the open carport were totes, spare wood, metal, and other miscellaneous building materials. Based on these observations, a notice of violation was issued for both the presence of junk and the unauthorized shipping container. A corrective action inspection was conducted on the 25th of August. At that time, the property remained in violation of both ordinances. As of my final inspection on the 13th of October 2025, the violations remain uncorrected. I have had ongoing contact with both the property owner and her husband and have previously explained the applicable ordinances and steps necessary to bring the property in compliance. Most recently, I spoke with Mike, the property owner's husband, and provided further clarification regarding the ordinance related to the shipping container, which remains in violation. I also want to say that when I did go out and do my inspection on the 13th of October, I mistakenly did not get a good photo of the Connex still on the property. So I did go out again yesterday. And on that case, there is a photo dated from the 14th of October.
Okay. Ms. Johnson, did you get the information you needed?
Well, the first time that I heard about it was when I got the certified, and that was the 13th. So I didn't have a whole lot of time I would have freaked out way earlier.
In other words, you didn't know about the case until October 13th?
September 13th.
Oh, September 13th, okay.
Right, but I mean, yeah, so I've been trying to figure out how to fix the violations. I have pictures because the debris, that's called debris and junk, were actually full sheets of plywood, over $100 a piece. Yeah, my husband is a pack rat, but I do have pictures to where I did fix that. As far as the Connex building, that's a monster of a project. I had no idea that they were illegal. I actually bought it from a company right on 19, and they happily delivered it. They gave me I bought hook, line, and sinker with a great thing about them. And they're also everywhere. Now that I know that they're not legal, I've even offered it. It's on social media in 4 different places because I don't have any means myself to remove it from the property. I have to have it removed. So that's my issue, is I need time, or I don't even know how much it would cost me to have it moved, and then where would I have it moved to? So I have big issues there.
Ms. Olson, what is the basis for the junk case? Is it just the plywood?
It's like the plywood, and it just looked like some building materials, from the road.
He's a contractor. Well,
yeah, from the road, to me, it looked like building materials, which she could have if, they were stored in an enclosed space.
which I did do that, and it's bright color because it's neon colored ratchet straps. The boards are, like I said, they're.
What about everything under the carport?
That's what he removed. He moved all that.
He removed everything
That's what it was. That was what the violation was.
for the stuff in the carport?
Yes.
In addition to the, I see a pile of, so I'm looking at page 1. Is that part of the violation?
Yes.
And it's gone?
All the junk and debris.
And is that gone?
I believe so. It was gone yesterday.
Okay.
I think it's really, as of yesterday, it's really just some of the stuff that's underneath, like the stuff that's underneath the carport structure.
All right. That shouldn't take long. To the extent that it hasn't been done yet, it would take 5 minutes, probably. Maybe
is done.
10. Huh?
It's done.
Okay.
I have pictures.
Okay. And then on the connection, or let's see, I don't know what kind of container this is. How much time do you need to get that off the property?
As much time as you can give me. Like I said, now that nobody wants it because apparently they're not legal in Citrus County. And it's 40 foot long.
All right. Let me, if you have photos that you want to introduce as evidence, I'd like to take a look at them.
Oh, they're pretty much the same as hers. I just wanted to show you the
No, I want to
evidence.
see. If it's gone, if it's abated, it's not. And if it isn't fixed, then I want us to be on the same page about what needs to be done.
Oh, okay.
Are you prepared to introduce that in evidence?
Yeah, it's just the same.
Yeah, it just means you have to part with it, so I want to make sure.
And I have a real good picture on my phone if I can show you.
I can't take that because I'd have to confiscate your phone.
Oh, you can have that.
Once y'all take a look at it.
You can have the whole thing.
Yeah.
It was from beginning to end. So I guess where we are is the Connex, and that is my biggest.
I don't know. I need to see the photos you've got to figure out about what I call the junk case. Certainly the container I mean, how did you get it on the property?
I bought it from Container Solutions on Highway 19, and he delivered it to my house. And there's like 50 of them on my way to work. They're everywhere. I had no idea that they were not legal.
Ms. Johnson, did you take these photographs?
I did.
When did you take these photographs?
2 days ago.
Okay. We have no objection. County's position is that they show a violation is still ongoing, as there's still all this
The one
stuff
on my-
under the carport. All of this would have to be removed.
It is now. That was.
Well, we'll get to that. So I'll ask questions about it. That's why I wanted to see it. I want to make sure we're talking about the same thing. So
Right.
I'll introduce this as Composite Exhibit C. It's got several photos in it. All right, so let me just see here. All right, so Ms. Johnson, you're representing that all these various, I mean, I'll call them building materials, but pieces of wood.
That is mid cleanup, and the pieces of wood, he's the big pieces of plywood. That's in the middle of him building the shelves. That's how he used the wood to remove it.
My question is, are they gone?
Yep.
All right, and Ms. Olson, is it the county's position that there are things she's allowed to have in that carport?
I would really have to look at the photos.
Okay, well, let's look at it. So this refrigerator, is she allowed to have it in the carport? No. Okay. Is that gone?
I think so. But I mean, that can be.
I
like,
don't
that's
know
5
about, that's not the most
That's
convincing.
5 minutes. No, I've got my picture on my phone, but my phone's.
All right,
Tell
well, well, so what I'm getting at is, I think that it may not be fully, I want to give you enough time to comply, okay? It would be my intention to give you 30 days on the junk case, because it's not a lot, but I think that you need time to make sure that it's done. And you'll need to, talk to the county and call Ms. Olson to make sure that it meets. All right, so that's that case. Let's talk about the container. Actually, what's the county's recommendation on the junk case? And then I'll talk to the public.
On both violations, I'm asking for $50 a day.
Okay, so I'm
plus
gonna grant
administrative
30.
costs.
Actually, is there anyone from the public who wants to speak about the junk case? Don't see anyone. All right, so in case number 25-1247, I'll grant 30 days to bring the property in compliance, and it'll be how much per day?
50.
50 if it's not brought into compliance. All right, so let's move that to the side, and let's talk about the container. Anything else you want to tell me about it? Anyone else want to speak about this case? All right, so what I will do is, I'll grant 90 days for you to abate the violation. If it's not brought in compliance as ordered within 90 days, it'll be a $50 a day fine. Okay? 3 months. Thank you.
Thank you.
Next case, Salamina Holdings LLC, case number 2025-1284. Code Officer Robert De Niro, expert on the case, Floral City Water, Kayla Woodard.
I do.
Please state your name, sir.
Philip Anderson.
And sir, are you an owner or agent of Salamina Holdings?
I am.
Did I get that right? Is it Salamina Holdings?
Salamina, yes.
Okay, thank you. Please proceed.
Good morning. Robert De Niro, Citrus County Code Compliance Officer, case number 2025-01284, conflict with Central Water Facilities, Section 42-39B, conflict with Central Water Facilities. Address is 7736 South Florida Avenue, Floral City. Property owner, Salamina Holdings, LLC. Good service, certified, signed receipt, and posting at Lecanto Government Building. I would like to authenticate the following documents and request
Before we
they
do
be.
that, can you give me a narrative? This is something I'll talk to you guys about at the end of the hearing.
Okay, yes, of
Yeah.
course. It's, the company has failed to comply with connecting to Floral City Water. They were given like a 365-day gate. They started 365 days ago and up to this point.
Sir, I mean, is that true?
I'm going to assume that it is. There's a little bit of background I'd like to.
Okay, then that's fair enough. Then, Mr. De Niro, I assume you have some exhibits.
Yes.
And sir, I'll ask you to take a look at those exhibits and let me know if you have any objection.
Okay, so just real quick, Exhibit A, copies of the notices from the utilities for the water connection, 365 days, 270 days, 180 days, 90 days, and the final 30-day notice. Exhibit B, copy of the notice of violation, copy of the notice of hearing, copy of the pre-order hearing, and a copy of the posting of the affidavit, and
Alright.
posting of that.
I just want to give you an opportunity, sir, to let me know if you have objections to me considering these as evidence.
I don't mind it at all, yeah.
Okay, all right. Without objection, what's been proposed as Exhibits A and B will be evidence. Thank you. I'll just quickly look through it. Okay, please proceed.
Yes, sir. On July 29th, 2025, I received a case for the failure to connect the public water system and found that there was no permit to connect. A notice of violation was issued on July 29, 2025. On September 4, 2025, I contacted the utilities and that no connection has been made and no waiver was given. On my final inspection as of October 14, 2025, there has been no permit applied for any contact regarding the connection to the water system. The expert on this case is Floral City Water Association, Kayla Woodard.
Ms. Woodard, how are you?
Good, how are you?
Good. Have you been sworn in, by the way?
Yes.
Okay. So what would you like to tell me?
So we contacted them July of 24. We've sent the letters that Mr. De Niro presented. I've spoken to him, and with no compliance, this is where we're at.
Okay, and I see you're also the notary on some of these. Are you just notarizing Mr. Wilson's signature?
Yes.
Okay. All right, that's it. Thank you. All right, sir, what would you like to tell me?
I'm going to play, this is my first hearing ever, by the way.
Welcome.
This,
Have you enjoyed yourself?
It's quite amusing in some ways, but I see the serious side as well.
That's exactly right.
I've been in Forest City for a while. I think I spoke to Kayla on the phone, and I'm up against a situation that probably is a little drama. I travel extensively. I'm only in Forest City on the weekends. So as far as any piece of paper that you guys have submitted me, other than this one, I probably haven't read the first one. That corner property in Floral City, it's an eyesore. I'm probably kind of surprised it's even made it to this point. When I say I inherited the problem, I bought it via court order through a real estate company, and I have not gone on the property until recently. Recently is because the situation was a family squabble, drama in itself. But anyway, court-ordered sale. I purchased the property. To be quite honestly, I didn't even know what I was going to do with the property, but I bought it. I own two corners there of the other fence lot adjacent to this as well. Probably the main point I want to make is unbeknownst to me and to my surprise, I haven't gone into property since I bought it until recently, and recently is because I had to do an eviction on the folks that were court-ordered to sell. The old house and the barn, there are fixtures there. They're probably 100-plus years old. Quite frankly, termites have to hold hands to hold this thing together. My plan is not to, I don't know what you would call it today, but it's jumper cable style. Apparently the former owners were not only still using the house for cooking, but the water source and you might correct me, Caleb, but the water source and electric was coming from a property just one house north. That's my understanding today. There's no water source there that I'm aware of.
I've not inspected the adjacent property. We can assume, but I have no idea where they're getting water at. I've not been on the property.
No, I understand, but the only way they could have been using this house and this property is water from somewhere, and I'm not aware of a well or anything. I do know there's no
That's
electricity.
not always the case. I'll tell you, I've seen everything, and
Well,
sometimes
I don't disagree. With property this old, I don't disagree. And these people have basically, their reputation has preceded them a little bit. I've been into some ugly situations just dealing with their property. I did have to have them evicted just a little while ago, and even another letter went to them just making them stay off the property. It's been in the last 3 weeks or 1 month. Have a contractor, Mark Powers. He's just gone through the submittal of a demolition of the property. That application actually is held up in the system, I believe, due to the tax, something's going on with you guys in the county right now. He's given me the explanation on my phone, but I don't want to revert to that right now. I did let Kayla know on the phone that my intent was to demolish, and it doesn't really make sense to do water meter there. Nobody's living there. We don't have a use for water or electricity there.
Ms. Woodard, actually, it raises an interesting question. Do we know if it's served by an on-site potable water system?
I'm not aware.
There's a building there, and so we assume that it has to be served by septic or otherwise, correct?
The house, maybe, the building, I don't know. It's an old barn. Again, this stuff's 100 years old.
I'm a little concerned. The code section only applies to buildings served by on-site potable water systems. So if we're not sure there is one, I'll set that aside for the moment. I hear what you're saying. You're saying if it's demolished, there's no connection that would be appropriate anyways.
No, I'm saying it will be demolished, yes.
Oh, I thought you were actually making an argument that, if it is demolished, that it doesn't need to connect to the water system.
I would have no need for water right now until I develop
Ms.
the site.
Woodard, or Mr. Denaro, whoever wants to answer this, if the structure was demolished, would there be a need to connect?
No. So if it's vacant land, we do not require a connection. If there is a permit, we could have abated this case, but there's nothing that I could find. I can't speak for the county.
Okay.
If there was.
When are you demolishing?
The permit was just applied for literally in the last couple of days.
And this is the application to demolish?
Yes, sir.
Okay, so do you have any guesses about when you might be able to get
I know that
from the permit to demolition, how long would that take?
I'm waiting on that information as well.
Okay.
I want to move as fast as possible simply because it is an eyesore corner. And one other point I want to make, and it's might be irrelevant, but to my dismay, and even to my contractor and my wife, you can barely walk through this house. It's not even 12 to 1,500 square feet from front to back door. I couldn't even believe people were inhabiting this to cook. So I'm kind of wondering why, it hadn't been condemned. I'm to be quite honest. I know it's made it through storms.
The county doesn't just have a right to walk into, there's property rights, there's things like that. And so
I understand.
It's really not here or there. Let me think about this for a second. Is there anyone from the public who wants to be heard on this case? What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $50 a day along with the administrative cost to begin after the date you deem sufficient to abate this violation.
I will give 90 days to either connect or to demolish such that a connection is not necessary. And if that doesn't happen within the 90 days, then there'll be a $50 a day fine.
Sounds like fun. So may I ask Kayla this question? How long will it take to connect?
You would have to fill out your membership application and make payment, and then it's 2 to 3 weeks for a meter to be installed, and for
So
us.
90 days would be,
Well, I don't think it would take long to demolish this, but in any event.
I respectfully want to make a couple of comments, When it comes to, this situation, obviously you can't go in people's bathroom and all this stuff, but whenever you can look under carports and all these things, this building is, it looks like it's just ready to fall in. How it's made it through any of the hurricanes, I have no idea.
Right.
Maybe the trees are protecting it. The water piece, I travel extensively internationally and the U.S., and I'm not up here that much, but in listening, I just want to, the fairness of it is, I got a lot of documents from you guys. We've had a couple calls recently only. On your board, Scott Mitchell Tree's a friend of mine, all these people, they have my phone number. So I would have almost appreciated a call rather than a series of letters, and even the sign out in front with the posting on it, I just saw the picture of. I drive by there 100 times. I never look at that kind of stuff because the building looks so bad. There's signs everywhere.
All right, so I'm going to respond to that.
I'm not avoiding my responsibility.
No, it's okay. I'll respond in a couple ways.
Yeah.
So, no, so the way it works in government law is that the reason why counties and cities have discretion in the exercise of their police power, which involves code enforcement, is that there is no way for them to literally patrol every structure without some kind of complaint-based system, which is what we have. So it's normally on the owners to try and take care of things, and by all accounts, it looks like you're trying to do that. Second, the reason why the notice obligation doesn't involve phone numbers is because it's very hard to guarantee or promise something like that, and they don't know who to contact to go get phone numbers. What they do and are able to do is look at the property appraiser website. So you as an owner maintain an address. And so that's why the law and what the Florida legislature maintains for all counties and cities is that it's considered correct notice if they send to the address on the property appraiser, because you get to maintain that. So the travel's within your control, and their ability to send notice to the address that you tell them is in your control. Now, I mean, I think this is a very interesting situation, but 90 days is more than usually is necessary for anything like this. Demolition is very simple, so.
I understand that as well, and pardon me for interrupting, but I've had other properties demolished, and gosh, everything from asbestos, all these things, there are delays involved in some demolitions.
That's true.
The old barn itself, you hear the stories of it being, they operated on Ford garage there at one time, all these things. So I don't know if I'm dealing with a soil condition. There's just a few things that
Well, I just think it's relevant that the notices here started in 2024. I do know, of course, that there is a return to sender on one of the 2024 letters, and I don't know if it was because of a failure to pick up, maybe, or whether it was because the address wasn't right, but I think this is a lot of time.
Yeah, I understand.
Yeah.
I'm not avoiding the responsibility.
No, I know.
I'm just also sharing with you, I have a very busy life, and I'm not here that much.
Join the club, sir.
Yeah.
Next case.
Next case, Francis J. Sizemore, case number 2025-1332, Code Officer Robert Gennaro. Expert on the case, Kayla Woodard, Florida City Water, page 36 of your agenda.
I do. Please state your name. Francis Sizemore.
Good morning still, ma'am.
Good morning.
All right. This is a similar case.
The same exact case. Yes, sir. Robert De Niro, Citrus County Code Compliance Officer, case number 2025-139. 332, conflict of central water facilities, section 42-39B.
All right, Mr. Gennaro. Ms. Sizemore, have you failed to connect to the water system?
Yes. Well, what I don't understand, I've got perfectly good well water. It's, I've had it tested, it's good. Then why should I be made to take city water when I got perfectly good well water?
I'll tell you, this is a very common and I think fair criticism, but fairness doesn't come into this because you have a code section here. The answer to your question is the law, because the law says so. So in this code section, it's 42-39B. It says that anywhere where there's an on-site potable water system like the one you have, regardless of how good it is, regardless of if you're fine with it, regardless of if it's cheaper and has 20 years to go, must connect to and utilize potable water from a publicly owned or investor-owned permitted central water system within 365 days after notification. That's it. And part of the reason is to justify the costs. When a county or a city puts in a water treatment or any kind of a water service system, it's a matter of volume for economy. Does that make sense? In other words, a water system that serves 2 people is not cost effective. A water system that serves 10,000 is more effective. A water system that serves 100,000 even more effective because everyone's paying into the cost of it. Does that make sense? So whether right or wrong, that's what the law says.
Do I have to use the water?
No, you can move.
No. If I hook up to it, I have to use it?
I can't advise you on that. All I can say is that this law requires a hookup.
I know I don't want their water, but...
I get you. So, Mr. Denaro, I assume you have some exhibits. When was the first notification in this case given?
Exhibit A, copies of the notice of utilities for the connection, 365 days, 270 days, 180 days, 90 days, and the final 30-day notice. Exhibit B, copy of the notice of violation, copy of notice hearing, copy of the pre-order, and a copy of the hearing posted at the property, and a copy of the posting affidavit.
Mr. De Niro, what date is on the 365-day notice?
July 18th, 2024. Okay. Thank you. Sorry.
That's consistent with, I think, the notice
yes.
in the other case. So you probably issued them all around the same time, right? Okay. Ma'am, do you have any reason to deny that you've gotten notice of it?
No, I got a notice, yeah.
Yeah. How much time do you need in order to comply with the hookup?
Well, it's according, how do you pay so much money to have it hooked up?
Ms. Woodard, are you able to offer testimony about that?
So Floral City Water does offer a payment plan if that's what you wish. The membership fee for your home is $2,400. We can break it down to a $500 deposit into 12 months. So it works out to be like $162 with your monthly bill.
And what is your monthly bill?
Our base rate is 0 to 4,000 gallons at $26 a month.
But when I get it, do I have to hook up to it and use it?
I believe the ordinance states.
How about if I just use it for my washer or my toilet?
Well,
so
y'all are going to have to get into that later. I just need to know.
Yes. Yeah, we can discuss that in the office.
So what I'm going to do is grant 90 days, okay, to connect. And what's the county's recommendation if?
The county's recommendation was $50 a day, along with administrative costs, beginning the date after you deem sufficient.
Is there anyone for the public who wants to be heard on this case? Okay, ma'am, why don't you come up? I need you to come up to the microphone and we'll get your name, swear you in, all the good stuff.
Hi. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Please state your name. My name is Ruth Hale, and I am a neighbor of hers, and they're doing the same thing to me. So I guess I understand what's going on. But I do have an appointment here on November 19th
Oh, okay.
So-
Well, I'm not going to prejudge your case,
No.
but you've got a
That's-
glimpse of what's coming down the train
Exactly, I
tracks.
just wanted to make sure that I still have to come down November 19th.
Unless you resolve it before then, I
Okay.
mean,
Okay.
which I always encourage you to do,
Yes,
okay?
okay, that's what I wanted to know.
So I'll be announcing a new policy on that at the end of the hearing as well, so.
Thank you.
All right. Okay, so 90 days, $50 a day if it's not brought into compliance, and we'll call it a day.
So I go down to the water company?
Please get in touch with Ms. Woodard.
I don't believe she was a no contest, so can we put the evidence in and have Your Honor accept it?
Yeah, sure.
Thank you.
It's been conceded. So, all right. You're done.
I'm done.
Thank you.
Thank you.
Next case is John and Jamie E. Roberts, case number 2025-1390 and 2025-1400. Code Officer Erica Olson, page 27 and 28 of your agenda.
Please proceed.
This is case number CE 2025-01390, accumulation of junk and debris, a violation of Chapter 20, Section, or Article 3, Section 20, TAC 31 Alpha of Citrus County Code of Ordinances. And case number CE 2025-01400, unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20, TAC 41 of the Citrus County Code of Ordinances. The address is 6281 Southeastern Avenue in Homosassa,
Brother
Florida.
Roberts is not here?
They are not, we have members of the public here.
Okay, gotcha. Thanks.
It's approximately 4.79 acres and zoned RUR-MH. Property owners John M. Roberts and Jamie E. Roberts. I have good service via posting the NOH on the property and posting at the Lecanto Government Building. I'd like to take the time to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 13th of August, 2025. Compliance inspection, 2nd of October, and my photos of my final inspection on the 13th of October. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the general pre-hearing orders, a copy of the posting affidavits, and a copy of the notice of hearings posted on the property.
Okay. Then the exhibits will be admitted without objection in each case. And can you tell me a little bit about what's going on?
On the 13th of August, 2025, I conducted my initial inspection in response to complaints received regarding junk and unlicensed vehicles on the property. During this inspection, I observed an RV parked near the roadway but still on the property with a license plate that was expired in 2014. Surrounding the RV were various items piled up under tarps and sheets, and there was also, it looked to be some building materials. A corrective action inspection was conducted on the 28th of August, 2025, during which the property was found to remain in a similar condition. Additional items were observed scattered around the RV. As a result, an NOH, notice of hearing, was issued. On the 2nd of October, I posted the property for hearing and confirmed that the property remained in violation. Pre-hearing inspection was conducted on the 13th of October, and the property
Have you had
remains in
contact
violation.
with the owner or people responsible?
No, not the owner. On one of the times I was out there, a gentleman was riding a bike up to the RV. I asked him if it was his. He said yes. He told me the owner's name was John, and that he was going to be moving the RV, but he did not.
Okay. All right, then I'd love to hear from members of the public who want to be heard on this case. Sir, why don't you come on up?
I do.
Please state your name.
Craig Duncan.
Thank you.
Mr. Duncan, good morning.
Good morning.
And what would you like to say?
Well, this all started back around June. They brought this motorhome. I'd like to look at those photos if I could, that she submitted. And it's got to the point now where in the evenings, when you drive, that vehicle is so close to the road that the reflectors, you think there's a vehicle backing off of the property. The people that attend there at night, they have fires back there to stay warm now. It's just rats. I ride my bike back through there all the time.
Rats, you mean actual
Absolutely.
vermin or?
I'm talking about rats that have the tails that, you know, and I know that the health department came out. I saw the vehicle there. They walked around the unit and everything, but it's right on, when they first brought it, it was 4 foot into the road for 4 days before we could get the sheriffs to actually get them to pull it in, to get it off of the road. And they had these cones out around it. I mean, it's absolutely absurd. And, you know, at night or even through the day, you just don't feel safe with the situation that's back there. That property, I mean, what's behind that is, I don't know how people can live there. And not just one person on the bike, but there's 15 to 20 people on bikes that come back there at night. It's a continuing situation.
Is there anything else you'd like to tell me?
I'm sorry?
Is there anything else you would like to tell me?
Yeah, I would like to get the situation corrected because it started in June and it's just getting worse. And now they've actually, where the RV is, I don't know if you've observed this, but they actually put a partition from the one tree over so you can't see back there. And when you're out there, it smells like urine and stuff. I mean, people are defecating all over the place. I mean, it's just absurd, but yet nothing seems to move on the situation. I mean, it's expired plates. I mean, motor vehicle should tow it out of there or something. I don't know the laws or anything, but it's absolutely absurd.
All right. Well, thank you, sir.
Am I set?
Yeah, I mean, unless you have more to say.
Nope, just
Okay.
said I hope you can correct it.
All right, thank you. Is there anyone else from the public who wants to be heard on this? All right, I don't see anyone else. What does the county want to do?
We request that you assess a fine of $100 per day per violation along with administrative costs. And that it's the respondent's responsibility to notify code compliance when they're ready for reinspection.
Okay. In each case, I'll find a violation exists. I'll assess a fine of $300 a day per violation and grant 10 days to bring it into compliance, each of them. All
Thank
right?
you.
Thanks. And I'll also just tell the members of the public, my powers are fairly limited here. You know, I can assess fines, but I can't, you know, I don't think I can authorize the county to actually pick it up and move it. So fining is pretty much the extent of my power. All right? Unless the county thinks otherwise. But, I mean, has the county ever used injunctive power that I've said, or no? Did those cases?
The case abated.
They always abated?
Yes.
Wow. Is there anything else on this case, on these cases besides, I mean, actually, I'm sorry, Ms. Olson, to bring you back up. Have you witnessed other people camping there or anything like that?
I haven't, but you know, I'm only there, they live there, so they're able to witness it all the time. I'm only there when I do the inspection, so I can only testify to, you know, obviously what I observe. I've only observed one gentleman there. I will say the junk, it is accumulating. Like every time I've gone out there, it's more and more. There is the partition up. You can, it doesn't do anything. You can still see the junk.
Well,
The
I
property
will.
just sits far back and we can't really see unless we get on to see. We can't see enough.
Well, I'll certainly authorize the county to go on and inspect what it needs to do in order to ensure compliance.
So the RV is up front, closer. I do think what the gentleman is saying is that, you know, for on the property, which you can't see from the road, there's so many trees, and the pictometry does depict that there is.
I'm authorizing you
A
to go
lot
on
of
there
stuff.
and
Okay.
inspect. All right,
Thank
thank
you.
you.
Next case, Jalen Royster, case number 2025-1313, Code Officer Robert DeNaro, page 29 of your agenda.
Okay, please proceed.
Robert DeNaro, Citrus County Code Compliance Officer, case number 2025-1313, conflict with Central Water Facilities, section 42-39B of the Citrus County Code of Ordinances. Address is 4885 South Whitetail Terrace, Floral City. Owner, Jalen Royster. Good service, posting of notice of hearing on the property and the posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, copies of the notice of utilities for the water connection, 365 days, 270 days, 180 days, 90-day notices, and the final 30-day notice. Exhibit B, a notice of violation, copy of the notice of hearing, a copy of the pre-order hearing order, a copy of the notice of hearing posted on the property, and a copy of the posting affidavit. On July 31st, 2025, I received a case for failure to connect to the public water system and found that there was no permit to connect. A notice of violation was issued on August 31st, 2025, and on September 4th, 2025, I contacted the utilities and found that no connection has been made and no waiver has been given. And as of my final inspection, October 14, 2025, there has been no permit applied for any contact regarding the connecting to the central water system. The expert on this case is Floral City Water Association, Caleb Willett.
Ms. Woodard, do you have anything to offer on this?
This gentleman has a home next door. We've spoken to him about his current account and his current home, but they've never contacted us about this case. So I'm assuming they're aware of it. They live next door, but I don't know.
Okay. What's the county's recommendation?
County recommends $50 per day along with administrative costs to begin with what you deem sufficient to abate this violation.
Do you have exhibits?
Yes, sir, I do. I have the exhibits that I stated earlier.
Okay, then without objection, they're introduced as exhibits A and B. Is there anyone from the public who wants to be heard on this case? No. Okay, then I will grant 60 days to connect or otherwise abate the violation, and it'll be $50 a day if they fail. Thank you.
Thank you.
Next case, Joanne C. Kessel, case number 2025-1314, Code Officer Robert DeNaro. Expert on the case, Floral City Water, Kayla Woodard. Page 21 of your agenda.
I'm ready.
Robert DeNaro, Citrus County Code Compliance Officer, case number 2025-1314, conflict with Central Water Facilities, section 42-39B. Address is 8110 East Skyline Lane, Floral City, Florida. The Joan C. Kessel Trust. Posting of the hearing on the property, posting at Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Copies of the notices from the utilities for the water connection for 365 days, 270 days, 180 days, 90 days, and the final 30-day notice. Excuse me. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the notice of hearing posted on the property, and a copy of the posting affidavit. On July 31st, 2025, I received a case for the failure to connect to the public water system and found that there was no permit to connect. A notice of violation was issued on on July 31st, 2025, and on September 4th, I contacted the utilities and found that no connection has been made and no waiver has been given. As of my final inspection on October 14, 2025, there has been no permit applied for or any connection regarding the connection to the central water system. The expert on this case is Floral City Water Association, Kayla Woodard.
Okay. Ms. Woodard, anything you want to say?
We have not had any contact with this case.
Okay. Then I will admit your exhibits A and B as evidence. Is there anyone from the public who wants to be heard? What's the county's recommendation?
$50 a day along with administrative costs to begin with your sufficient, what you deem sufficient to abate the violation.
60 days, $50 a day. Thank you.
Next case, Shanitha Lynette Gates, case number 2025-1561. Code Officer Robert De Niro, expert on the case Joanna Coutu, page 13 of your agenda.
Robert De Niro, Citrus County Code Compliance Officer, case number 2025-01561, special requirements for all accessory uses in violation of Citrus County Land Development Code 3102A. Address is 3337 East Griffin Street, Inverness, Florida. Owner, Shantea Lynette Gates. Good service via posting of hearing on property and the posting at the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Photos taken during my initial inspection on September 2nd, 2025. Photos taken during my corrective action inspection, on September 19th, 2025. October 3rd, 2025 posting, and my photos of my final inspection on October 13th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the posting affidavit. This is a vacant property that is 0.44 acres and is zoned medium-density residential. On September 2nd, 2025, I conducted an initial inspection and observed the structure on the property. On October 2nd, 2025, a notice of violation was issued for special requirements for accessory use. On October 19th, 2025, I conducted a corrective action inspection and found that the property remained in violation and had no permits applied for or issued. I had no contact with the property owner. There was a building permit for the property, but has since expired on December 16, 2023, and no certificate of occupancy has been issued. As of my final inspection on October 13th, 2025, the property remains in violation. No permit has been issued or applied for. My expert on this case is Joanna Coutu.
So what I can say is they had a permit. It expired December 2023. There's been no action since then.
Okay. All right, then I'll admit the exhibits, and I'd like to take a look at them. Thank you. Any contact with the owner?
No, sir.
Yeah. Wow. That's impressive grass, or what is that?
That's next month's case.
That's what?
That's next month's case.
Oh, is it?
Yeah.
I mean,
yeah,
that's amazing.
Yeah.
Jeez. That's Snake City right there.
Yeah. You said it.
All right, what's the county's recommendation?
The county is asking for $100 a day along with administrative costs after you deem sufficient date to abate the violation.
I know I've asked this before, but does it abate if they get a permit, a new permit, a building permit?
They'd have to restart. This is a 2020 permit. The building code's
I
changed.
know, but I mean, if they got it, if they got the permit.
Traditionally, the answer to that question is yes. However, I know code has indicated when they've previously had a permit and just let it expire, they want them to go through all the way through to the CO since.
To abate? This
to abate.
violation?
Because they've previously had the violation and we got here because they never finished it. So just getting the permit in this case, they do the exact same thing, we'd be here again in a year and a half.
I'm concerned about that. That's why I'm asking, because if I give a certain amount of time, there's no way to get a CO.
We've talked about establishing, which was the CO, yeah, establishing the use on the site, not just getting a permit to use it for that.
And yet, if it had been vacant to start with, and they didn't have the permit, normally it's the issuance of the permit.
Correct. We
that
give them a good
abates it.
faith basis that they're gonna go all the way through with the permit. They've kind of already had the good faith basis, and so that's why in this case, we want to abate it actually.
They might have a good faith reason for not following through, though, too. I mean, I know they're not here, I just, I don't want to set someone up for failure. Compliance is the name of the game. If they get a permit, can I justify requiring that the only way to abate it is the CO if in the other situations I only require a permit? There's nothing in the code to suggest that it should be treated differently.
Mr. Wah, we've had orders for that before. Yes, sir.
That I've expressly held, they have to have a CO in this kind of a situation?
Until a principal use is established.
Yeah, well, no, I agree. I mean, there've been a lot of cases like that, but I thought that once they get the permit, that's what abates the violations for this kind of thing.
Once their principal use is established, then they'll already have their CO, and then.
Well, I know that, but what I'm saying is, on another case where they have let's say that it's a vacant piece of land and there's a bench there. They're not allowed to keep it.
Correct.
It's storage on a vacant. But normally, it was my understanding that once they get a building permit, they can have the bench there.
Our good faith basis is that getting the permit is the start of the process for the development. So that lets them start putting a house on there, and that's establishing the use. So that on this case, though, in these types of cases, I can probably count on one hand the number of ones we've ever had where they build a whole house and just walk away.
Yeah, there haven't been that many.
It's not often.
No.
But they've already had the opportunity to go through and do it properly. They've gotten a permit, they've shown they know how, but they just walked away from it. So in that case, they'll just walk away again. We're gonna be here again in a year. It's established a pattern of behavior that's different than the other cases you're talking about, which is why we would want the CO in this case.
Would there be a repeat in that case?
It could still be considered a repeat, yes.
On this particular one, we're coming up on 2 years. It has actually expired as a permit, so it's been sitting for a while too, just on
I'm not
this
denying
one.
there's a violation. I
No,
mean,
I understand.
I'm trying to think what a reasonable time would be without unfairly punishing.
And I think the problem could become, I haven't done the legal research because honestly, until you brought it up, it's not something that I ever researched. If you say getting the permit abates it, and they get the permit, and then they let it die again, they've already been tried for that violation. I'm not sure if we could file another because they've already, but they haven't done anything new. They haven't repeated, they're not doing anything new.
Yeah, but
It's
they
the
abated
exact
the
same.
violation. It was a violation. They abated it. It happens all the time with
Okay.
all your other cases. I mean, well, for whatever it's worth, it would be new to me.
Okay.
So you don't have to worry
Okay,
about
well,
that.
I just don't want to put us in a box where if
I
you
would
do
never do
decide
that. Yeah.
that that's it, we
I'll
can't bring
stick
it
to
back.
my, what I tell you. All right, anyways, what's the county's recommendation?
County recommends $100 a day along with administrative cost after you deem sufficient date to abate the violation.
Okay, I'm going to give 90 days to abate, I guess. And if it's not brought into compliance as ordered, $100 a day.
And since we had a conversation about what abating means, what does abate mean in this case?
Yeah, I think that I would give less time if it was just a permit. But if what you're asking me to do is require a CO, then I'm going to give 90 days.
Okay.
I'm not going to hold myself to that in the future, but I think we'll go with that for now.
Thank you, Your Honor.
Yep.
Next case, Ronald Santigata Jr., case number 2025-1539, Code Officer Erica Olson, page 33 of your agenda.
This is case number 2025015339, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20, Tax 61 of the Citrus County Code of Ordinances. This is a repeat violation initially observed on September 4th. The address is 6225 South Esmeralda Terrace, Lecanto, Florida 34461. Property owner is Ronald Santagata, was previously found guilty on November 20th, 2024. Case number, and that was 2024-01679, was $0 in imposed fines. I have good service via posting the NOV, NOH on the property and posting at the Lecanto government building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, the findings in fact and order acknowledging compliance from the previous case, 2401679. Exhibit B, photos I took during my initial inspection on the 4th of September, photos I took in my subsequent inspections on the 22nd and 24th of September, and photos from my final inspection on the 13th of October. Exhibit C, a copy of the notice of violation / notice of hearing, a copy of the posting affidavit, a photo of the notice of hearing, notice of violation, notice of hearing posted on the property, and a copy of the general pre-hearing order.
Okay. The exhibits are admitted without objection as evidence. I don't see anyone else from the public, by the way, so I'm not going to ask for that anymore. You took the photos on the dates indicated?
Yes, sir.
Yeah. Oh, yeah. Okay. What's the county's recommendation?
We respectfully request that the special master assign a fine of $150 per day along with applicable administrative costs for the period during which the property remained in violation. Request that the fine commence on the date of the posting of the property, which was September 4th, and continue to September 24th when the property came into compliance. This represents 20 days at a rate of $150 per day, which equates to $3,000.
Okay, it's so ordered.
Thank you.
Next two cases, Christopher D. Rizzuco, case number 2025-1391 and 1405, Code Officer Cody McGuire, page 30 and 31 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer. These are case numbers 2025-01391, accumulation of junk and debris, a violation of the Citrus County Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and also case number 2025-01405, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. And the address is 9469 West Hertford Lane in Crystal River. It's 2.33 acres and it's zoned AGR. The property owner is Christopher D. Rucco. Good service via posting a notice of hearing on the property and posting at the Canto Government Building. I'd like to authenticate the following documents and request that it be admitted into evidence. Exhibit A is photos taken during initial inspection on August 13th, 2025, corrective action inspections on August 27th, and photos of my final inspections on October 14th of 2025. And Exhibit B is a copy of notice of violations, copy of the notice of hearings, and copy of the posting affidavits, and photos of notice of hearings posted on the property and pre-hearing orders.
Okay. All are admitted without objection as evidence. And you took the photos on the dates indicated on them?
Yes, sir.
Have you had contact with the owner?
No, sir.
All right, let's look at the overgrown, unkempt lawn case first. All right, that's an open and shut case. What is the county's recommendation on that?
$100 per day.
And on the junkyard conditions case, I will look at it. What's the county's recommendation on that case?
Same as well with $100 per day.
Have you heard anything about where the owners or tenant or,
No, unfortunately, every time I'm there, even when posting the property, I haven't had any contact with anyone.
Okay. Then what I will do is I'll find that the property is in violation in both cases, and in each case, grant 14 days to bring the property into compliance. If it's not brought into compliance as ordered, $250 a day fine in each case.
Thank you.
Thanks.
Next case, Brian H. and Z.A. Boone, case number 2025-1426. Code Officer Robert DeNaro, page 9 of your agenda.
I'm ready.
Robert DeNaro, Citrus County Code Compliance Officer. Case number 2025-01426, excessive growth and accumulation of vegetation in violation of Chapter 20, Article 6, Section 2061 of the Citrus County Code of Ordinances. Address is 1017 Columbia Lane, Inverness, Florida. Owners Brian A. and Z.A. Boone. Good service posting of the hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Photos during my initial inspection on August 19, 2025, corrective action inspection on September 2nd, 2025, and October 2nd, the posting and photos of my final and the postings of my final inspection of my final inspection conducted on October 13, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, copy of the general pre-order, photo of the notice of hearing posted at the property, and a copy of the posting affidavit. The property is a single-family residence, which it's on 0.11 acres and is on MDR. On August 19, 2025, I conducted an initial inspection and observed grass and weeds in excess of 18 inches. On August 19, 2025, a notice of violation was issued for excessive growth and accumulation of vegetation. On September 2nd, 2025, I conducted a corrective action inspection and observed that the property remained in violation. And as of my final inspection on October 13th, 2025, the property remained in violation. I have had no contact with the property owner.
Okay. Well, then the exhibits are admitted without objection. I'd like to see them, and then what is the county's recommendation?
County's recommendation is $100 along with administrative costs after the date you deem sufficient for this violation.
14 days, $250 a day. Thank you.
Thank you, sir.
Next case, Casey Hardy, case number 2025-1452. Code Officer Robert DeNaro, page 15 of your agenda.
Robert DeNaro, Citrus County Code Compliance Officer. This is case number 2025-1452, accumulation of junk and debris in violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 8071 East Garner Lane in Floral City. Property owner Casey Harding. Posting of good service via posting of the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos during my initial inspection on August 22nd, 2025, correction action inspection on September 9th, 2025, and October 2nd, and the photos of the posting and the photos of my final inspection conducted on October 13th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the hearing posted at the property, and a copy of the posting affidavit. This property is a single-family residence of .11 acres and is zoned coastal lakes and residential mobile homes allowed. On August 22nd, 2025, an initial inspection is conducted. I observed shopping cart furniture along with miscellaneous junk and debris on the property. On August 22nd, 2025, a notice of violation was issued for the accumulation of junk and debris. On September 9th, 2025, corrective action inspection was conducted on the property, and it remained in violation. As of this inspection on October 13th, 2025, the property remains in violation, and I have had no contact with the owner.
All right, the proposed exhibits are evidence in this case.
Yes.
I'd like to take a look at them. And just let me know what the county's recommendation is.
County recommends a fine of $100 a day along with administrative costs after the date you deem sufficient to abate this violation.
Did you say you had not had contact with the owner?
No.
Who's that walking?
That
on-
woman just ignored me when I tried to talk to her.
Okay. All right. 14 days, $250 a day.
Next case, Jim Ray Johnson, case number 2025-1675, Code Officer Julie Wilkinson, page 19 of your agenda.
Good afternoon.
Good afternoon.
Yes.
Which case is this? Oh, Jim Ray Johnson. Okay, all right.
This is a repeat violation initially observed on September 17th, 2025. The address of the violation is 48 South Lincoln Avenue in Beverly Hills. Case number is CE 2025-01675, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The property owner, Jim Ray Johnson, has been previously found guilty of the same violation at the same location on March 17th, 2022. That case number is 215-3704, with $0 in imposed fines and administrative costs. That case was abated on May 17th, 2025. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the...
Wait, I just want to make sure. So I thought you said that it was a repeat from March 17th, 2022, and then it abated on May 17th, 2025?
That's correct.
Is this one of my cases?
Let me see.
I gave over 2 years to bring it into compliance. But it said $0. I thought you said $0.
Yeah, I'm not sure why that is, but
Okay. I'll try. It's okay. I mean, I'll look at Exhibit A. It's no big deal.
Okay.
Sorry.
Yes. Exhibit B, photos taken during an initial inspection on September 17th, 2025. Photos I took during my subsequent inspections on September 25th, October 2nd, and the final inspection on October 14th. Exhibit C, a copy of the repeat notice of violation and hearing sent to Jim Ray Johnson, a photo of the notice of violation and hearing posted at the property, a copy of the general pre-hearing order, and a copy of the posting affidavit.
All right, what's been proposed as Exhibits A, B, and C are admitted as evidence. And let me ask you, did you take the photos on the dates indicated?
Yes, sir.
It looks like another pretty open and shut case, although you also have, I'm assuming you took a picture of the, I don't know, like dead grass detritus or whatever it is on the driveway.
Yes.
Because that's an accumulation.
Yes.
Oh, yeah. Okay, what's the county's recommendation?
Because the case did abate yesterday, when I went to do the inspection, asking for $150 a day, plus administrative costs to begin on the posting of the property, which is September 19th, and continue until October 13th, 2025. That's 26 days at $150 a day, totaling $3,750.
Okay. Really confused by this. There's no doubt, I mean, the dates as reported are all correct. It was an order signed by me. There's an order acknowledging compliance on September 18th, 2025, signed by me, pursuant to an affidavit that I reviewed from Ms. Wilkinson. But I guess the missing link here is I don't know if there was ever a fine recorded on the property.
So I believe, if I may, what happened was the previous code officer had forgotten to do the affidavit of compliance. There was an inspection conducted at the right time.
Oh, I see.
So when I got this case,
There was never any argument that it was brought into, back in the day.
Yes.
And so when this came on your radar,
I had to.
you fixed it, you
Yes.
jimmied it. Okay, all right, then that's fine. Okay, I find that this is a repeat violation, and for the dates indicated on the record, there'll be a $150 a day fine.
Thank you.
Thanks.
Next case, Martin Kaplan, case number 2025-1499, Code Officer Cody McGuire, page 20 of your agenda.
Ready.
All righty. Cody McGuire, Citrus County Code Compliance Officer, case number 2025-01499, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5130 West Maple Leaf Court in Lecanto. The property owner is Martin Kaplan. I have good service via posting the property and Lecanto Government Building, and I would like to authenticate the following documents and request that it be admitted in evidence. Is going to be Exhibit A, photos taken during initial inspection on August 28th, 2025. Photos taken during a corrective action inspection on September 22nd, 2025. And photos of my final inspection conducted on October 13th of 2025. And Exhibit B is a copy of notice of violation, copy of notice of hearing, copy of the general pre-hearing order, a photo of the property posted, and a posting affidavit.
Okay. What's been proposed as Exhibits A and B are admitted as evidence. You took the photos on the dates indicated.
Yes, sir.
Did you tell me if you had contact with the owner?
I haven't had contact with the owner either.
And looking at the photos. Yeah.
I originally had 2 cases on this, and the overgrown lawn had abated.
That was the easier one to take care of, I suppose, but this is not a complicated, difficult junk case.
Well, the garbage can's right there, too.
Right. What's your recommendation?
This is going to be $100 per day.
7 days, $200 a day.
Thank you.
Thanks.
Next case, LL Molders Real Estate LLC, case number 2025-1513, Code Officer Julie Wilkinson, page 22 of your agenda.
This is case number 2501513, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31 of the Citrus County Code of Ordinances. The address is 16 South DeSoto Street in Beverly Hills. The property owner is LL Mulder Real Estate LLC. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request it be admitted into evidence. Exhibit A, photos taken during an initial inspection on August 28th, 2025. Photos from a corrective action inspection on September 5th, 2025, and photos from a final inspection conducted on October 14th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photos of the notice of hearing posted at the property, and a copy of the posting affidavit.
Okay, exhibits A and B are admitted without objection. Thank you. You took the photos on the dates indicated?
Yes, sir.
Contact with the owner?
With the owner?
Or tenant?
No contact.
No contact. Looks pretty bad. What's the county's recommendation?
$100 a day.
Okay. Has there been improvement or no?
There was improvement because there was a huge pile of trash in the backyard which
Okay,
got removed.
so that's gone.
That's gone, yes. So the neighbors are happy about that because they're not smelling it, but there's still junk outside.
Okay. 10 days, $250 a day.
Thank you.
Next case, Rehab Rescue Group LLC, case number 2025-1637, Code Officer Robert DeNaro, page 26 of your agenda.
Ready?
Robert DeNaro, Citrus County Code Compliance Officer. This is a repeat violation initially observed on September 12, 2025. The address of the violation is 266 South Otis Avenue, Lecanto, Florida. Case number CE 2025-01637, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 2061 of the Citrus County Code of Ordinances. The property owner is Rehab Rescue Group LLC, has been previously found guilty of the same violation at the same location on September 2nd, 2022, case number 21-68367 with $0 imposed in fines and administrative costs. The case was abated on August 21st, 2022. Good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, finding of facts and the order acknowledging compliance from the previous case number 21-68367. Exhibit B, photos taken during my initial inspection on September 12th, 2025, and the photos I took on my subsequent inspections on September 15th, 22nd, 29th, and 30th, and October 8th, and my final inspection on October 14th, 2025. A copy of Exhibit C, a copy of the repeat notice of violation and hearing sent to Rehab Rescue Group LLC, a photo of the notice of violation and hearing posted on the property, a copy of the general pre-hearing order, and a copy of the posting affidavit. This property is a single-family residence of 0.09 acres and is zoned medium-density residential. I conducted my initial inspection on September 12, 2025, and observed an overgrown lawn and with grass and weeds exceeding 18 inches. I posted the repeat notice of violation on the property on September 12, 2025. I conducted the following follow-up inspections on September 15th, 22nd, 30th, and October 8th. On October 14th, I conducted a final inspection and found that the property remains in violation. I have had no contact with the property owner.
Okay. Exhibits A, B, and C are admitted as evidence. And what is the county's recommendation?
The request the special master assess a fine of $150 a day along with the administrative costs beginning on the date of the posting, September 19th, 2025, and continue to October 14th. That would be 26 days at a total of $150 a day for $3,900, and a $250 fine from the date forward until the violation is abated.
Okay. I'll take a look at the photos. Thank you. Okay, the prior fine in the prior case in 2022 was $50 a day. So based on that, I find the recommendation reasonable. I'll find that this is a violation and a repeat at that. It'll be a fine of $150 a day from the dates recommended and $250 from today's date forward.
Thank you, sir.
Thanks. Oh, that's it? Oh, okay. So I did want to talk about a couple things. One is, I think I am going to start factoring in the length of your investigations more. In other words, from the time that someone comes out there. So I don't know if you want to explain that to them, if that comes up in your conversations, but it may be relevant for discussing the no contest stuff, because you may come to better terms than if it ends up being a 6-month investigation, and I don't think they should get the benefit of knowing that there's a violation for that period of time, regardless of when the hearing is set. And second, I'd like to talk to you all about maybe rethinking the manner of presentation, because I know this is the way it's always been done. I mean, as long as I've been here, where the initial presentation is given, the exhibits are authenticated, but it occurs to me that it might be more helpful to know the narrative up front. In other words, just to know in 1 or 2 sentences what I'm going to be looking at, instead of the authenticating exhibits and then being told what it's about. I think that's more useful for the respondents as well, because I think it kind of puts the cart before the horse.
So I think of it in terms of like criminal cases, since that's my background. We always provide that it's junk and debris so they know what it is, but you want more of like the layman's narrative versus the legal narrative to go before the evidence comes in.
Well, I was a prosecutor myself, and I always remember in an opening not just telling them this is a battery charge and you'll get some. I explained to the jury what they would see, So I think the narrative is helpful both for me and for them. It's just, you can present the cases however you wish, but I often am in a situation where I'm looking at exhibits before I even know how they're relevant.
Okay.
You see what I'm saying?
Yep.
It's just something I've thought about. That's why, because I've been asking for the narrative, kind of inserting myself. I don't know. I just think it would make it flow better. That's just my own belief. So I'm not trying to get in the way of what y'all do. But that's all I wanted to put in front of you. So
We'll work it out.
Is there anything else?
No, sir.
Okay, then the time is 12:30. This hearing is adjourned.